So we do have, it looks like we have everyone back. So we're going to go back on the record now. In the case of Cayla Griffin versus Albanese Enterprise, Inc., DBA Paradise, the case number is 2019 CA 1555, and plaintiff's present, plaintiff's counsel is present. The court reporter is keeping the record. We have Mr. Smith, our trial bailiff, present, Ms. Hodak, our special magistrate, and Mr. Muse, who is our remote jury bailiff, present. And Mr. Kaczurgas, can you and your client see and hear me?
I can, Your Honor.
Ms.
Yes,
Griffin?
I can.
Very good. And Mr. Smith, any problems from your end on the technology side? You're muted, Mr. Smith.
No, sir. We just request that juror number 87 has a time issue.
Right. So we're going to go ahead and get that. Like I said, the first order of business is we're going to, when we bring them into the courtroom, we're going to have them sworn in. We're going to go to the, I'm going to go to the remote sidebar, put 10 minutes on the clock. And then what we'll do is we'll go out of order. Instead of calling 81, 83 first, we'll call 87 first so we can address her work issue so she can get out of here in time to go back to work if that's the outcome of the sidebar. And so that's our order of business. Mr. Muse, you're still going to gavel me in.
Yes, sir.
And so that's the plan. So Mr. Muse, let me ask you this. Have all of our jurors watched the PowerPoint presentation number 1 for Zoom skills needed for jury selection? And has Mr. Corrigan had an opportunity to confirm all their identifications?
Yes, Your Honor.
All right. Are you ready to bring all the jurors into the remote courtroom?
Yes, Your Honor.
All right. Very good. All right. The remote jurors are now entering the courtroom. Mr. Muse, are all of our prospective remote jurors present and accounted for?
Yes, Your Honor.
All right. You may proceed, Mr. Muse.
The Remote Circuit Court Division for Duval County in the state of Florida is now in session. The Honorable Bruce Anderson is presiding remotely. Except for the remote jurors and the electronic devices they are using to participate in this court session and the attorneys and their assistants, everyone please turn off all cell phones and electronic devices at this time. The attorneys and their assistants should have their cell phones and electronic devices silenced or on vibrate mode. The use of cell phone cameras or other electronic devices to take photographs or make video or audio recordings of these remote proceedings of any kind is absolutely prohibited. However, those of you in the remote gallery may use your electronic devices for purposes other than photography or making any video or audio recordings of these proceedings while remote court is in session. Credentialed representatives of the media who have obtained prior approval from the court may use cell phones, cameras, laptops, iPads, and tablets, and any other electronic devices, and they may be used for photographic and or recording purposes. There will be no talking while remote court is in session unless your microphone is muted. Except for the attorneys, everyone in the remote courtroom, including the remote jurors, should have their microphones muted unless called upon to speak or instructed to unmute their microphones.
Thank you, Mr. Muse. Good afternoon, ladies and gentlemen of the remote jury panel. My name is Judge Bruce Anderson. I will be the judge presiding over this remote jury selection as well as the remote trial. I would like to welcome you to the Remote Civil Division CVE of the Circuit Court, 4th Judicial Circuit, NM4, Duval County, Florida. With that being said, I want to tell you that from a personal standpoint, yesterday and today have been 2 of the happiest days I've had as a judge since the COVID crisis hit, because I've been able to welcome jurors like yourselves to the remote courtroom yesterday and today to once again see jurors again interact with jurors. It's really been a pleasure for me, and I'm so happy and pleased that you're here. I also understand, on the other hand, that some of you may not be feeling the same joy and happiness I am, and I totally understand that. I know there's at least 3 of you that have issues, pressing issues that you want the court to hear with regard to hardship. So I'm going to do things a little differently than I've been doing yesterday and this morning. And so what I'm going to do at this time, I'm going to ask Mr. Corrigan, our deputy clerk, Brian Corrigan, to now come onto the screen. And Mr. Corrigan is going to administer the oath to you. And so from this panel and the panels that appeared yesterday and this morning, we're going to pick 8 jurors to try this case. But before we begin, Mr. Corrigan's going to need to administer the oath to all of you as prospective jurors. The oath simply means that you will answer all of our questions during jury selection truthfully and completely. Before administering the oath, I will ask our remote Deputy Trial Clerk, Mr. Corrigan, to confirm for the record that by the display of each prospective juror's photo ID, that each one of them were summoned for remote jury duty and is duly qualified to serve as jurors by their written responses to Part B of their summons submitted in advance of their appearance today. Mr. Corrigan, can you confirm that?
I can, Your Honor.
All right, ladies and gentlemen, the prospective jury panel, please unmute your microphones for Mr. Corrigan.
Please raise your right hand. Do you solemnly swear or affirm that you will answer truthfully all questions asked of you as prospective jurors, so help you God?
I do.
I do. All right, thank you, Mr. Corrigan. As I said earlier, I'm going to do things a little bit differently. We have several of you with pressing issues. And so what I'm going to do is I'm going to ask our remote bailiff he's going to be placing on the screen a stopwatch, and that's going to have 10 minutes on there. And so I'm going to address the 3 hardship issues at the remote sidebar. So I'm going to advise our remote bailiffs that the court will need to go to the remote sidebar conference. I'll need Ms. Hodak, our special magistrate, at the remote sidebar conference. I'll need our court reporter at the remote sidebar conference, and Mr. Kachurgis at the remote sidebar conference. And then the following order, I'm going to be bringing jurors in individually to discuss their hardship. The first juror will be juror number 87. Ms. Miller will bring her to the remote sidebar conference first. And then when Ms. Miller returns to the remote courtroom, we'll bring in order juror number 81, Mr. Moberly, and then juror number 83, Mr. Gelwicks. And so one by one, we'll inquire on the hardship. So for the rest of you, I'm doing this a little differently. For the rest of you, you're immediately going to have a recess for 10 minutes. There'll be a clock on the screen. You'll see it count down. During these 10 minutes, you can take a bathroom break, you can have a snack, you can get a beverage, or you can tend to whatever you need to tend to. You can put laundry in the dryer, put something in the crock pot, deal with any chores around the house. But please don't discuss this case or what's going on in here. Don't attempt doing research about the case or people or places involved in the case. So we'll be in recess now for 10 minutes, and those of you that I mentioned by name will receive an invite to go to the remote sidebar conference. Ms. Miller, you'll get the invite first, and then, like I said earlier, we'll go to the other 2 jurors. So at this time, we'll go ahead and put the stopwatch on the screen, and then those of us that I mentioned earlier will go to the remote sidebar conference. Thank you for your patience. All right, Mr. Muse, our remote jury bailiff, are you available?
Yes, Your Honor.
Mr. Muse, can you confirm for the record that all of our jurors are present and accounted for?
If you give me one moment, Your Honor, let me double check here.
With the exception of number 86.
Yes, Your Honor. All present and accounted for.
Thank you, Mr. Muse. I welcomed you earlier, and at this time, I'm going to have to say farewell to some of you. So I am doing this a little differently than the previous panels, but I do appreciate your patience in allowing me to do the remote sidebar conference so early on with 3 of your fellow jurors. But I do feel like that their issues are so pressing, I had to address them early. And so with that, I do need to state for the record, I am excusing juror number 86, who was unable to join us here this afternoon due to a sudden medical issue that came up. So I'm excusing juror number 86 for hardship, Katie Blanton. And then as to jurors 81, 83, and 87, Mr. Moberly, Mr. Gelwicks, and Ms. Miller, I'm also excusing the 3 of you for hardships as well, based upon your testimony at the remote sidebar about your present situations. So I thank each of you for your service here today and for coming to this historic remote jury selection. And the only thing I'm going to ask you to do is I really need you to respond to the email you're going to receive. You're each going to receive an email from one of our remote bailiffs that's going to give you instructions. It's going to thank you for your service. It's going to give you instructions on how to get a work excuse or excuse that you're going to need for your employer, for your school about where you've been today. But it's also going to have a link to a very important survey. And even though you're not going to be joining us for the entire jury selection day, we really need you to answer that survey because it's going to provide us with very useful information that we can use as we go forward with this pilot program. And the Florida Supreme Court will be reading it as well to learn what we can do better or different moving forward if we're going to continue to use technology in jury trials in the future. So I'm really asking you to complete those surveys as soon as you receive them. And with that being said, we thank you so much for your time and attention here this afternoon and for answering the questionnaires and at least going through this part of the process. Thank you for your service. Have a good day and a good weekend and stay safe and stay healthy. Thank you. You can now leave the remote courtroom.
Thank you.
Thank you. All right, I believe we have all of our remaining jurors still left with us. And so I'm going to pick up where I left off at the beginning. And so I want to start by thanking each of you on behalf of my colleagues here in the 4th Judicial Circuit for being here today and offering to serve as a remote juror. The judges in this circuit realize that service on a jury, whether it be in person or remote, is a sacrifice, and it can interfere with your task of daily living, whether that be your duties and responsibilities at home, your duties and responsibilities at work, or whatever the case may be. However, service on a remote jury affords you an opportunity to be part of the administration of justice where the rights and liberties of the citizens of our community are determined and protected. The first thing I'm going to need to do here this afternoon is confirm who each of you are and ask some very routine technology questions that will help us as we move forward today. So I'm going to go in order, in chronological order, by your juror number. I'll begin with juror number 76, Ms. Jackson. Good afternoon, Ms. Jackson. You can unmute your microphone. Good afternoon.
Hi.
Ms. Jackson, you are Megan Renee Jackson, is that correct?
That is correct.
Ms. Jackson, can you hear me?
Yes, I can.
Can you see me?
Yes, I can.
What device are you using to participate today?
My laptop computer.
All right. And thank you. That takes us to juror number 79, Centoria Johnson. Good afternoon, Ms. Johnson. You can unmute your microphone.
Good afternoon.
Ms. Johnson, can you hear me this afternoon?
Yes, I can.
Can you see me?
Yes,
What device are you using to participate today?
an iPad.
All right. Thank you so much, Ms. Johnson.
You're welcome.
That takes us to juror number 80. Is it Ms. Maher or Maher? You can unmute your microphone.
Oh, pardon me. It's Mrs. Maher.
Maher, okay. Ms. Maher, you are Judith Williamson Maher, is that correct?
Yes, it is.
And can you hear me today?
Yes.
Can you see me?
Yes.
All right. And what device are you using to participate today?
A laptop.
All right. Thank you so much, Ms. Maher.
You're welcome.
That takes us to juror number 84, Mr. Pearson. Good afternoon, Mr. Pearson. You can unmute your microphone, sir. I do that all the time. Good afternoon.
better?
Sir. Yes, sir. That's much better. Good afternoon, sir.
Good afternoon.
You are Thomas Harry Pearson, is that correct?
Yes, Your Honor.
Mr. Pearson, can you hear me?
Yes, sir.
Can you see me?
Yes, sir.
What device are you using today to participate?
My old, still works, mobile phone.
All right.
That's all I've got access to.
All right. What kind of mobile phone is it?
It's an iPhone,
Okay.
2006,
Do you know which one it is? iPhone 5, 6, 7?
number 6.
Okay, iPhone 6. All right. Well, it seems to be working quite well despite its age, so it's working well.
Mm-hmm.
All right. Thank you, sir.
You're welcome.
That takes us to Betty, is it Schofield or Schofield?
Schofield.
Schofield.
Yes, sir.
All right. How are you doing today?
I'm doing great. Thank you.
Good. Can you hear me?
Yes, sir.
Can you see me?
Yes, sir.
All right. What device are you using to participate today?
An iPad.
All right. Thank you so much.
Thank you.
If at any time during this remote jury selection or during the remote jury trial itself, you're having trouble hearing what the court is saying or what anyone else is saying or seeing anyone or anything on the screen, please raise your hand, either your real physical hand or your Zoom hand, or get our attention by saying something, anything at all to get our attention so we can correct things. We don't want to go forward here this afternoon without you being able to see us or hear us. You all have received several emails from our remote bailiff since you received your summons. And in those emails, there would have been a contact number provided to you, a contact cell phone number. Did all of you receive that contact cell phone number for our remote bailiffs? I need a verbal response. Go ahead and unmute your microphones.
Yes, I did.
Yes.
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 All right, very good. If it sounds like everyone said yes, but if anyone did not receive it, please raise your hand. All right, let the record reflect that all the jurors have received that emergency contact number for our remote bailiffs. That number serves two purposes. One, it provides you kind of a lifeline. If all your technology goes out, things go dark, or the screen goes blank, and you lose everything, and we don't have any way to see you or hear you, then that number is going to allow you to get in contact with someone right away to get technology help. The second reason that you were given that number is so you can provide that number to your friends, family, coworkers in the event there's an emergency and they need to get a hold of you. That's going to be the number that they call if they need to get a hold of you. And that number that information, if there is an emergency, will be relayed to me, and we'll close down the process long enough for you to deal with whatever that is. I do have some very, very basic things I need to discuss with you, some ground rules, so to speak. But before I get to those ground rules, I do need to tell you that in advance, because this is the second day that we've done this, we've had a few technical problems along the way. This is a brand new process, and we're learning as we go, so to speak. And we do have technical problems from time to time. I do want to thank you in advance for your patience and understanding as we work through the remote jury trial process and remote jury selection process. So in advance, I'm telling you there may be some delays due to technical problems, and thank you in advance for your patience. The basic ground rules that we have for jury selection have been developed based upon some practice or mock trials that we did for the past several weeks. And they're basically 10 basic rules that we've come up with that are really dedicated to Zoom or remote trials. These are not rules I would be giving you if you're here for an in-person trial. So listen very closely. I don't have them memorized, so I will be reading them for the most part. Number one, you must treat every court session the same way you would if you were physically at the Duval County Courthouse. If you were to walk in through the physical doors of the Duval County Courthouse and have a seat in one of our courtrooms, you'd be expected to put away your newspapers, your work, your magazines, your iPad, your computer, your phone. All that stuff has to be put away so you can focus just on us. And so you have to do that with a remote trial as well. Number two, do not turn off your video while court is in session. We all need to be able to see each one of you, and you need to be able to see each one of us. I promise I will not turn off my video while we're together while court is in session. Number three, do not get up and leave your Zoom meeting room. Don't leave the remote courtroom while we're in session. In other words, don't get so comfortable with the process that you feel like you can get up and leave and go to another room and take care of whatever you've got to deal with in another room, or go deal with something at work, or go take care of something that's going on outside. Please don't get up and leave the remote courtroom. If there is a sudden emergency, you were provided that number I told you this morning, or this afternoon, you were given that number in your email so that you'd have a number to provide to others if there is an emergency. Number four, please focus on the screen and the audio source of the device from which you're participating in this remote court session. In other words, we want your total focus on the screen of whatever you're using to participate, and on the speakers they're providing you with the audio, whether that be a headset or whether that be some other speaker, external speaker somewhere else. Number five, there should be no other sights or sounds coming or devices competing for your attention here this afternoon, or distracting your attention away. So if you've got a radio on, or you've got a television on, or there's something else in another room that's competing for your attention, whether it's sight or sound, all that stuff needs to be turned off and shut down. We want your attention totally on us. Number six, while remote court is in session, you cannot speak to anyone else in person or by an electronic device, whether it's someone that's in your home that might be right down the hallway or in another room, or if you're at your office, someone else in another location in your office, a family member, coworker, anyone at all. You cannot talk to them while we're in session. If there are other persons in your home or office that get your attention, they have an emergency, they've got to speak with you right away, there's a medical emergency or a fire or something very immediate and urgent that you have to deal with, please let us know, and we'll take a recess for you to deal with those, with whatever that situation is. Number seven, you may have noticed, if you haven't used Zoom before, you may have noticed that there's a chat feature. If you've used Zoom before, you may have even used the chat feature. There's a chat message feature that you can use for sending messages to other participants. If this was a business meeting or a social get together, or what some people call a Zoom happy hour that people do to get together socially, all that messaging would be perfectly acceptable and would be expected. But here, while we're in court in the remote court session, you cannot send chat messages to other participants. Under no circumstances should you send me a chat message. Do not send a chat message to Mr. Kachurgis, the plaintiff's attorney, or Ms. Griffin, the plaintiff, or to the clerks, or to the court reporter, or anyone else that's participating here. However, you are allowed to send chat messages to the remote bailiffs and the remote special magistrate, Ms. Hodak. But you should not send any of those messages to the remote bailiffs and special magistrate while court is in session. You can only do it during recesses. The only exception to that is if you're having a sudden emergency, something very urgent, you need a comfort break, or you've got a technology problem, anything like that that's very urgent that we have to deal with right now, and they'll let me know, and we'll take a recess so that you can get all that squared away or deal with whatever that urgency is. During recesses, you may not only send, you may send chat messages to the remote bailiffs and special magistrate, as I said before, but also the special magistrate and the remote bailiffs also have my permission to send chat messages to you within the limits of their duties and responsibilities. They may send you a message that says, mute your microphone, or they may send you a message that says, we need to take a break because you've got a technical problem, or they may, any number of things within their responsibilities, they may send you a message for. As it concerns your fellow jurors, you've got several on the screen there right now. You probably have never met each other before, but over the course of this remote court session, you may be thinking, well, I'd like to message that person. Maybe there's something that we could discuss. Do not send messages to your fellow jurors. Not at all. No chat messages whatsoever to your fellow jurors. However, when we're in recesses, like the recess we took at the beginning of the proceedings today, although I don't want you sending chat messages to your fellow jurors, you are allowed to talk to each other when court's not in session. So if we have to take another recess before we finish today, you're in the Zoom platform. You can talk to your fellow jurors about anything in the whole wide world, just not this case or the people or places involved in this case. So that leaves a whole lot of other subjects you can talk about: news, weather, sports, vacation plans, any number of things like that, but just not this case. Why do we have all those restrictions on the use of Zoom chat messages? That's because we don't want you looking at your screen, typing away at your keyboard and sending messages to other participants, other jurors, and engaging in all of that, because now your attention is not on these proceedings, it's on typing a message or on reading a message. So we don't want you doing that while court is in session. Also, number 8, many of you have cell phones, tablets, laptops, or other electronic devices, including Apple Watches or other types of watches that can send and receive data with you here in the remote courtroom. So during this jury selection, any such electronic devices not being used by you to participate in the remote jury selection must be powered off. That doesn't mean airplane mode or silent or vibrate, completely powered off. You cannot have any such electronic devices in the remote courtroom once the trial begins. During the trial, you may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. When your service is done, I guarantee you, with all the media coverage that's on these proceedings and also with Courtroom View Network broadcasting it for free, you can go look at it for free. You can go watch yourself and look at each other as much as you want after this is over. There's plenty of opportunities to do that once your service is completed. But please, for the here and now, don't record and don't take photographs. Please don't try to communicate. If you are selected to serve as a juror in this case, and you get to the point where you're deliberating a verdict, you must not communicate with anyone outside the remote jury room about your deliberations or anything for that matter. You have to be completely locked in and locked away from any distractions while you're deliberating. The court will be able to receive messages and deliver them to you without delay by your family members, friends, and coworkers using that emergency number. Number 9, as it concerns whatever electronic device you're using to participate in this remote jury selection this afternoon, At this time, if you haven't done so already, I want you to turn off or log out of any websites, social media, messaging services, email providers, direct messaging, or instant messaging. I don't want anything at all to pop up on your screens that's going to distract you from these proceedings. So please get that off your screen right now. I don't want to have a split screen. We had one young man yesterday morning who was very candid with the court. He was a college student, and he was unable to focus on what we were doing because he had his research paper on half the screen and these proceedings on the other half of the screen. He was trying to do two things at once, which in an office or school setting is certainly admirable, but not in these proceedings. We have to have all of your attention on this case. So please get out of anything on your screen other than this case. Number 10, last but not least, because of the historic nature of how this trial is being conducted remotely, there will be, and there already has been, media and news coverage of this jury selection, both yesterday's proceedings and today's proceedings. I can guarantee you right now, there are media covering what you're doing right now. Also, we have Courtroom View Network, also known as CVN, broadcasting this trial for the public to watch for free, just as the public would be able to do if they walked into an in-person jury trial here at the Duval County Courthouse and walked into a physical courtroom and took a seat in the gallery. For the here and now, until you find out whether you were in fact selected or not selected to serve on this jury, do not attempt to watch any news coverage of this trial or any recordings of this trial until after your jury service is completed and you are discharged. So if for some reason this afternoon you receive an email saying you were not selected, you're free to watch as much as you want to watch. If you receive an email that tells you that you were selected to serve in this case, absolutely you cannot watch anything or look at anything until after your service is completed, either late on Monday or at the worst on Tuesday. Okay, I need you to unmute your microphones for this. This is a very important question. Did you all received emails after getting your summons with the questionnaire that you answered? And then also there were some links to 2 videos that were in the email for you to watch before today's proceedings. There was one from the clerk's office that was Mr. Corrigan, the deputy clerk, was the one who did that video. And then second, there was a video from the Florida Supreme Court. Did all of you watch those videos that were in the links in your email? I just need a verbal response, yes or no.
Yes,
Yes, sir.
Mr. Pearson, did you watch it?
Yes, sir.
Okay. And so all of you watched both of the 2 videos, is that correct?
Yes, sir.
Yes, sir.
All right. I appreciate you doing that. Did any of you have any difficulty watching those videos?
No, no, sir.
No.
Okay. Everything worked according to what you were hoping for in terms of playing smoothly and everything else.
Yes.
Yes, Your Honor.
Right. That's going to be helpful for us going forward with the project and knowing how well the technology worked for you all. And as it concerns the Florida Supreme Court video, it is such an important video. I think it really sets the right tone for these proceedings today. So I'm going to ask our remote jury bailiff and remote trial bailiffs to please prepare the video to share screen with you. They're going to show it to you using the share screen feature for Zoom.
Good morning, friends. Welcome to your judicial system. And I am Fred Lewis. I have the privilege of serving you as your Chief Justice. And while I'm in Tallahassee, all of us are vitally concerned at what's happening in the local community today, as you have reported for jury duty. And make no mistake, I use the phrase your judicial system because this system does belong to you. It will not operate without you, and it exists solely to serve you. It does not exist to serve the judges. It does not exist to serve those who work within the building, but it exists only to resolve disputes between our government and the citizens, between citizens, and involving businesses when those disputes cannot be otherwise resolved. Now, I know all of you have come here this morning with different anticipations and from different settings and from different circumstances, and we understand and recognize that. And we understand the sacrifice that many of you have had to make to be here this morning. But I hope you truly understand that by your being here, whether you serve on a jury or not, that it is extremely, extremely important that you be here because so many cases will be resolved in other parts of this building while you're sitting here waiting, because those individuals know that a fair-minded group of individuals are here ready and prepared to hear the evidence and make a decision. I think you need to understand that the reason you are here is that we trust you, the citizens of the state trust you, I trust you as a fair-minded group of individuals willing to take time from your day-to-day activities to participate in this democracy and make decisions for the government on the only opportunity that you will ever have. I know that it may have taken you away from some other things that may be important to you, but I cannot overstress to you how important it is that you're here today, that you're participating, and that you believe in this great democracy. As I was riding to work this morning, I came in behind a van that said, "Freedom is not free, just ask any soldier." I think we need only ask also any juror. Liberty and freedom is not free. We will not remain a free people without the jury system, and you're part of that system and you're making this happen. Thank you very much for being here.
All right, we're back on the record after watching the video. I'm going to start the same way I started earlier, which is to confirm if you could unmute your microphones. I need to confirm with each one of you that you can hear and see me coming back from the video.
Yes.
Yes.
Can all of you hear me and see me?
Yes, sir.
Yes.
Right. If anyone has trouble hearing me or seeing me, please raise your hand. And no one has raised their hand, so everyone can hear and see the court at this time. So in thinking about today's jury selection and also in preparation for yesterday's jury selection with 2 panels yesterday and 2 panels today, and the importance of your service as you answered your call to remote jury duty, some memories came back to me as I've been thinking about this for the past couple of weeks as we prepare for the first remote civil jury trial. And my memories went back to a time about 5 years ago before I was elected as circuit court judge. And it was December and the end of a 4-week, very complex civil jury trial with all the surrounding stresses of the holiday season and the time demands and the inherent stresses that go with a very complex civil jury trial. I was one of several trial attorneys that were trying the case. We got to the very end of the trial and all the excitement and anticipation of the holidays were upon us. You kind of have that ability to take a deep breath because the trial's over and we're getting ready to be discharged and court's about to go into recess. And the judge was giving the jurors their discharge instructions. And I noticed that there was a middle-aged man with his jury service completed who had tears in his eyes, or the tears were starting to form in his eyes. And I thought to myself, he must have tears of joy that after 4 weeks, his service is over. And he spoke to the court and asked if he could address the court and the lawyers. And this was a middle-aged man who had served his community in the military. He served his community as a firefighter. And here he was, this very strong man who was tearing up. His voice was trembling with emotion as he asked the court for permission to speak. And when he was given permission, he addressed all of us, the judge and all the attorneys who tried the case. He told us with that trembling, emotional voice that it was an honor and a privilege to serve on the jury. He compared the sound of freedom that he heard in the military, the sound of jets roaring and the sound of guns blasting, to the sounds that he heard in the courtroom during the trial. The testimony of witnesses, the arguments of the attorneys, the objections to court, the objections that were made in the court, the rulings made by the court, and the instructions given to the court. He hoped, at the end of his statement, he said he hoped that the sounds of freedom he heard in our courtroom would never end. I'll never forget that talk. I'll never forget that statement. It only took him a few moments to say it, but it's something I'll never forget. However, since the COVID-19 crisis began in the middle of March, the Duval County Courthouse has been very, very quiet. There's been very limited public access. All the hearings and non-jury trials that have been held in the courthouse have been held by Zoom video conferencing, which is what you're on today, or by telephone. We as judges, with the cooperation and the hard work of the attorneys and the court personnel, have followed the Florida Supreme Court's orders to keep our cases moving forward within the limits of technology, to keep things going. We've done that to the best of our ability. But despite all of our hard work, as it concerns civil jury trials, the sounds of freedom from our courtrooms have been silenced by the COVID-19 crisis since mid-March. You each received a summons for your remote jury duty. It may not look like an invitation. I've seen it, it looks like an official government document, looks like something that's ordering you to do something, which it is, but it's really an invitation. It's an invitation for each of you to participate in this great American experiment of self-government that has been conducted for over 244 years. You may be sitting there in front of your screen right now saying, why me? It's a hot summer afternoon. I've got plenty of other places I can be and things to do. Why me? Why does it fall on me to do this today? The answer to that question is found at the very beginning of the United States Constitution. The preamble to the Constitution begins with the phrase, we the people. 3 words, a very simple phrase, we the people, but it's so powerful because especially when you read it in the context of the preamble to the Constitution. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. 3 very powerful words. In our Constitution, we establish a system of government in which we the people are sovereign. In order for our government to function, we the people are required to individually participate in government of the people, by the people, and for the people. A quick review of the United States Constitution reveals other areas besides jury duty where you can participate individually in government, such as the right to vote, the right to assemble together for peaceful purposes, such as worshiping at your church, going to work, peaceful protest, and of course, military service. When citizens like you participate in government, it makes our Constitution come to life. I'm not talking about the legal scholar debate of whether our Constitution is a living, breathing document versus the textualist view, which is it's strictly construed as it was written by our founders. I'm not on that level of discussion. I'm not even entering that discussion. What I'm really talking about is something more basic, which is the fact that when you participate individually in our government, the great words of our Constitution come to life. They become great acts of service and sacrifice. Without your individual participation, our Constitution is just paper and words and nothing more. It doesn't take on any life or meaning beyond that piece of paper. It's you, it's we, it's all of us as people that make it work. To sum it all up, each of you were summoned here to participate in remote jury duty because you are the source of constitutional power. We the people are the source of constitutional power. Our court system would not work or function fully without you, the jurors. Each of you are making history today. You're each restoring the sound of freedom to Duval County Courthouse by your remote appearance here today. You're making history today because you're part of the first ever in the state of Florida and probably the first ever totally remote civil jury trial in the United States. Totally remote from jury selection through verdict. None of you will ever come to the courthouse during this trial. You will stay home or in your office or wherever you're choosing to participate from for the entire trial. The lawyers will not be in the courthouse. The witnesses will not be in the courthouse. The court reporter will not be in the courthouse. The special magistrate will not be in the courthouse. The trial clerk and the remote bailiffs will be in a completely different area of the courthouse. There's one remote courtroom bailiff, Mr. Ashley, who's with me right now in the physical courtroom 601 at the Duval County Courthouse. I am by myself in this courtroom. There's no one in the jury box. There's no one in the gallery out there. Only Mr. Ashley and myself are in here and a whole bunch of screens. And your verdict, if you're selected to serve as one of our 8 jurors, your verdict will be binding. It will mean something. It won't be fake. It won't be an advisory opinion. It will be binding. Even though you will never physically come into the Duval County Courthouse, it will be binding. With all that being said, you heard me initially engage three of your fellow jurors in a hardship inquiry. And that was because of the answers they gave in their questionnaires that they filled out before jury selection. So I did not detect any hardships mentioned in your questionnaires when I reviewed them in advance. And if I overlook something, I'm going to take this opportunity to inquire further to see if any of you have a hardship. But in order for you to really be able to answer that question with any degree of certainty to confirm whether or not you have a hardship, you have to have some idea of what to expect in terms of a schedule. So today, your only obligation today is to finish the jury selection. Sometime this afternoon, the jury selection will be completed and you'll be you'll be in recess. I won't be able to discharge you because we don't know if you'll be selected or not. After you're done today, I'll meet with Mr. Kachergis and his client, and the 8 jurors in this case will be selected at that time. And but you'll be in recess this afternoon while you wait to hear from us one way or the other. That'll be your commitment today. And then if you're selected to serve on this jury, you will be back with us on Monday morning at 9 a.m. You would get an email with specific instructions on how to log in with Zoom. You'll be assigned a virtual background, and you'll be joining us at 9 a.m. on Monday morning for the remote trial. My anticipation is that this case will be completed on Monday. So your service would begin on Monday morning at 9 a.m. and you'll be given the case in your hands to deliberate sometime Monday afternoon. Once you're deliberating a verdict, there's no time limit on how long that can be. That could be as short a time or as long a time as necessary for you to consider all the evidence, the instructions given to you by the court, and reach a unanimous verdict. That time I can't set for you. That's up to you. But with that being said, there is a very slight possibility that this may go into Tuesday morning. The reason I say slight possibility is because we are doing things completely different. This has never been done before. And yesterday and this morning, we did experience some technological glitches. And so those things are to be expected. And that could mean that we get a little delay because of the technology issues. If that happens, we may go over into Tuesday morning. However, while you're with us, whether that's just on Monday or Tuesday, I will take breaks every 60 to 90 minutes. It's usually at least a 15-minute comfort break in the morning. You'll have a lunch recess in the middle of the day, and then 1 or 2 comfort breaks in the afternoon, depending upon where we are with the case. You may have the case in your hands by Monday afternoon earlier rather than later. So we'll have to see how all that goes on Monday. But I will take breaks. If you need more breaks more frequently than that, you can let us know, and we'll certainly do so. And if you need any special accommodations in terms of breaks, a specific definite time, we can accommodate that as well. I know most of you are going to be concerned about being away from home or work for that length of time. I mean, all of you have other obligations, so any length of time is going to be significant to you. But I do, before you respond to the question of whether you have a hardship, I would ask each of you to consider what is at stake here today and on Monday. The Bill of Rights in our federal constitution and the Declaration of Rights in our state constitution guarantee all of us the right to a trial by jury to resolve our civil disputes. This is a very important right. It dates back to the very founding of our country and is the cornerstone of our system of civil justice. It means that the citizens of our community, applying the laws that we all must follow, determine the rights and liberties that are at stake in each civil case. We use the term service when we speak about jurors and their duties, because your selection as a juror is a significant service to your community. Outside of voting and serving in the armed forces, I do not know of any more important service you can provide to your fellow citizens in your community. because the right to a jury trial is meaningless without your participation. Quite simply, neither I nor any other judge can afford the citizens of this community the right to a trial by jury if I do not have anyone that is willing and able to serve as a juror, whether that's in person or remotely. Because of the importance of the right to a trial by jury, a hardship has to be something more than inconvenience or a disruption to your life. If that were the standard that had to be reached to excuse jurors, we would never have any jurors to serve on any trials, because every juror is going to say it's inconvenient and it disrupts my life. And so the best way for me to explain what a hardship is to maybe give you some examples of things that I've found to be hardships in the past. That would include something like a medical condition that prevents a person from sitting for the required time, or maybe a prescription medication that prevents you from focusing or affects your ability to stay awake and alert and follow things. It could be that you have to care for an ill family member or someone with special needs, and there's no one to cover for you. It could be that you have young children and there's no one to help you with child care while you're serving as a juror. We're in the summertime, so it could be that you have a non-refundable ticket for a cruise or airline tickets or some trip somewhere or hotel reservations at a resort, and you can't rework that schedule, and it's non-refundable, and you'll lose money and lose the opportunity to go on the vacation. It could be that you're a student and your professor is not willing to work with you, or your teacher is not willing to work with you to accommodate your change in schedule and won't reschedule your test or your deadline to get your project done. That can happen. Again, I know that participation as a juror in a 1 or 2, at most 2-day jury trial calls for a sacrifice. I hope you will consider how important the right to a jury trial is to preserve that freedom we all enjoy before you decide in your minds whether or not you have a hardship in this case. So with all that being said, I'm going to ask all of you whether or not any of you feel like that you have a hardship. If so, I need you to respond verbally. Go ahead and unmute your microphones. Do any of you have a hardship with the schedule I've just told you about this trial?
No.
No, sir.
This is Tom Pearson. Can I talk?
Yes, sir.
It's not really a hardship, but the only thing I have access to is this cell phone. And you said earlier, well, it seems like it's working pretty good. Well, that's not always the case with this phone. I'm a little bit concerned that it might act up during the trial.
Okay.
And I'm not trying to make an excuse. I do want to do this.
And
I just thought I'd mention that.
No, that's very good that you brought that up, because one of the things that we've done when we put together this project was we were anticipating, because we have a committee that's been working together on this project since June. So we've been having meetings and doing practice trials since June. And so one of the topics that came up is, what if we have a juror that either doesn't have technology, or their technology is such, either because of age or because of compatibility, it's not going to work very well for Zoom. And so we don't want to have anyone not be able to serve because they don't either have access to technology or don't have technology that's current enough to work well. You're getting through this just fine so far, Mr. Pearson, and I understand your concerns. But here's what we've come up with as a workaround. Our court technology officers, we have a great group of court technology officers. They, in my opinion, they're the very best court technology officers in the state of Florida. From Pensacola to Key West, we have the very best court technology officers. They have been working with the city of Jacksonville and our library system to come up with an alternative. We have public libraries located throughout the city. They're offering up small conference rooms where you'd be by yourself with a computer, camera, everything set up perfectly by court technology officers, where you could literally go to that library branch. You won't have to worry about COVID, because you'll be isolated and in a separate room, and you would have your own computer and device. You could participate from a library. Would that be something you'd be willing to consider, Mr. Pearson?
I told the man yesterday when I talked to him, we're pretty paranoid about this COVID thing. I've got pretty bad asthma and breathing problems.
Okay.
And my wife has COPD. She's 75.
Okay.
And we don't go anywhere.
Okay, I understand.
I mean, if you order me to go, I will, but
I'm not going to order you to go anywhere because we want to hear if there's a hardship or a concern, we want to hear it. I would never order you to go somewhere that you are not comfortable going to in this current scenario that we're in, which is unheard of. We haven't had anything like this in over 100 years in this country. And I'm never going to order someone to do something that's going to put them in fear of putting their health at risk. That's why we're doing this trial remotely, to give our citizens an opportunity to participate in their government without risking their life in the meantime. And so we don't want you to risk your life. We don't want you to do anything that's going to be an undue risk to you. All of us have a different risk tolerance. All of us have, we're in different stages of our life, different ages, different comorbidities. And so we all have to take those into account, deciding what we're going to do, whether it's going to the grocery store or going to work or socializing, whatever that may be. We all have to make all those decisions for ourselves. I'm not going to order you to put yourself or your family at risk, Mr. Pearson. So it sounds like that from your perspective, you're going to see how it goes with your iPhone 6, but with the understanding that things could fall apart on you. And if it does, then you would not be comfortable going to the library as an alternative. Is that correct?
fair enough.
Okay, all right. So that's, I appreciate you telling me all of that, and that's very good information for us to know. So I don't believe I heard anyone other than Mr. Pearson raise an issue. Did any of our other jurors have any issues with hardship?
I do, Judge Anderson.
Yes, ma'am.
I don't think it's a hardship, but I
And
do
for the
have
record, let me interrupt, Ms. Schofield. Let me interrupt because I have to keep a good record here. So for the record, Madam Clerk Reporter, this is juror number 85, Ms. Schofield.
Yes, I'm sorry.
That's okay. That's my
have-
fault, not yours.
Oh, I have a health issue. I don't think it would interfere with my court responsibility, but I do, when I take it, I can't drive. I have to take it 2 days a week. It's pain medicine. I have what they call burning mouth syndrome. It's the nerve endings in my mouth burn.
Oh,
And I'm on medication, but I don't think it would interfere with my jury duty.
okay.
I just can't drive.
Okay. So the medication you take, what days of the week do you take it?
I take it every day. I
Oh,
take
every
a
day.
pill in the morning. I take a pill in the morning and one at night. And I can give you the name of it if I need to.
No, ma'am, that's okay. Mr. Kachergis will have an opportunity to inquire further. But my question of you is, if you take it in the morning and then take it at night, when you take the medication, are there certain side effects that you have on a regular basis that prevent you from driving?
Yes, I get dizzy.
Okay. That dizzy feeling, does it kind of go away towards the middle of the day and then you get it again at night when you take it again?
Yes, yes.
Okay. So how are you feeling right now? Are you feeling dizzy?
No, sir. I feel
Okay.
fine now.
That dizzy
I'm
feeling.
getting better with it. It doesn't affect me near as much. I think my body is adjusting to it. I've been on it 6 weeks.
Okay.
So I'm getting much better.
So Ms. Schofield, let's say you were selected to serve on this jury and you have to come back Monday, not to the courthouse, but to the remote courtroom from your home and to serve as a juror at 9 a.m. Would this medication be something that would prevent you from focusing, knowing that it'd be morning time and you might have more of those symptoms in the morning than midday?
I don't think it will affect it. I just can't drive. If I move fast, it bothers me.
Okay. Well, we won't have you moving fast if you're participating in a remote trial. You can be seated and be at rest. You don't have to, you're not going to be running around or walking or moving. So if you're in one place like you are now, do you feel any symptoms of dizziness?
No.
Okay.
I can tell I can't see as well, but other than that, I can hear. So.
Do you feel like the medication would make you drowsy as well?
It can. Me staying busy during the day, it don't affect me, but now I go to sleep real good at night.
Okay, well, here's my question, because this comes up in an in-person trial. Sometimes when people serve on a jury, I'm here in a courtroom right now. Over to my left, there is a jury box. Those chairs are over there, and sometimes people get in there and they're sitting still. They can't get up and move around, and they can't walk and all that. They got to stay in the jury box. And sometimes they get a little tired. That's why every 60 to 90 minutes I take a comfort break. So you would have to sit there in your house, wherever you're at right now, whether it's your office, kitchen, bedroom, wherever you are, you'd have to stay there during the trial, not get up and leave. Do you think you'd have trouble staying awake in a remote court setting?
I don't think I would have any problem staying awake. I'm not in a, I mean, I'm in a cushioned chair, but I'm not like on a sofa.
Okay. Well, so far, how are you doing? I know it doesn't hurt my feelings if you say it hasn't been the most exciting afternoon of my life. It doesn't hurt my feelings whatsoever. But being here with me now and your fellow jurors, do you feel like it's difficult to stay awake and alert?
No,
Okay. All right.
no.
Well, thank you for letting
And
us.
it's very interesting.
Okay, good. Well, I'm glad to hear that. You're making me feel better then. So, Ms. Schofield, is there any reason right now, as you sit here with us now, that you would feel like that your medication would prevent you from serving on a remote jury?
No,
Okay.
not on a remote. I
Right.
just knew I couldn't drive down there.
All right. So let's see how things go this afternoon. And as things go, if you suddenly, if whether I'm doing the questioning or talking or Mr. Kachurgis is doing it, please let us know if for any reason you feel like that this is getting to the point where you're feeling drowsy or dizzy and you start to have a different opinion than you have now about your ability to serve. Okay.
Okay.
All right. Thanks so much
Thank
for your
you.
honesty. Anyone else have any hardship type issues that they would like to bring up other than Ms. Schofield and Mr. Pearson? All right. Then I'll take that as no hardship from our remaining jurors that are here today. That's juror number 79, Ms. Johnson, juror number 80, Ms. Maher, and juror number 76, Ms. Jackson. No hardships from any of you all. All right. I now need to follow up on another matter from your questionnaire. So we are one of 5 circuits in the state of Florida who are awarded this pilot program. Only 4 other circuits are doing it besides us. And so that means we're doing a lot of things that have never been done before. You are doing a lot of things that have never been done before, believe it or not. By the fact that you answered our questionnaire online, that's something that's never been done before. And when you do things that have never been done before, that means that we could have things that don't go according to plan, because that's how we learn. That's how we grow and learn. We develop and improve. This pilot program is going to end October 2nd, and we're going to have to make a final report to the Florida Supreme Court about the program, and you're going to be answering surveys and things of that nature. And so because this has never been done before, we're learning some new things. And one of the things we learned with your juror questionnaire was that we made a mistake. When I say we, it's really me, because I'm the one that's responsible at the end of the day for making sure everything goes well. Everyone's been great. All the volunteers have done a great job in helping us put this together. But at the end of the day, it's my responsibility. But what we learned from one of your fellow remote jurors, not from this panel, but from one of the previous panels, is that we didn't allow enough room in the juror questionnaire to provide complete information on litigation history. You may remember that questionnaire had basic biographical questions that we wanted from you, your date of birth and area of town you live in and all that. We also had you provide us with your prior history in terms of employment, what your spouse does, number of children. We had you provide information about whether you've been a juror before and whether you had a hardship. And then we had this section that I call litigation history, where it was your opportunity to tell us if you've ever been a party to a lawsuit, or one of your family members has been a party to a lawsuit. And one of your fellow remote jurors said that we didn't allow enough room to give a complete history. We only allow for the report of one prior experience. And so I want to know if any of you all had that same experience. Did any of you all feel like that in answering the questionnaire that you didn't have enough room or enough opportunity to give your full litigation experience in the questionnaire? So if you did have that problem, please raise your hand, let us know so I can follow up on that. Anyone have that problem? You can go ahead and unmute your microphones and give me a verbal response.
No, I didn't.
All right, thank you, Ms. Johnson.
No, Your Honor.
All right, thank you, Ms. Mayer.
No, sir.
All right, thank you, Ms. Schofield.
No, Your Honor.
Thank you, Mr. Pearson. Ms. Jackson, did you have any of those problems?
No, sir.
All right, great. Well, I'm glad to hear that. Thank you for your input on that. I now need to introduce the case and the participants to you. The name of this case is Plaintiff Cayla Griffin versus Defendant Albanese Enterprise, Inc., doing business as Paradise. Later during the remote jury selection, I will provide you more details about the subject matter of this case. For now, you should be aware that this is a civil trial involving allegations of battery by 2 employees of the defendant. A civil trial is different from a criminal case where a defendant is charged by the state prosecutor with committing a crime. The subject of a civil trial is a disagreement between people or companies. Where the claims of one or more of these parties have been brought to court to be resolved, it is called a trial of a lawsuit. The first order of business is to introduce you to the court personnel and the participants in this trial and explain their various roles to you. As I stated before, I will be the judge that presides over this case. You may hear people occasionally refer to me as the court. That is the formal name for my role. My job is to maintain order and decide how to apply the rules of law to the trial. I will also explain various rules to you that you will need to do your job if you're selected to be a remote juror. It is my responsibility to remain neutral on all the issues involved in this case. You'll see appearing on the screen Ms. Corrine Hodak. Ms. Hodak is our special magistrate for the 4th Judicial Circuit's remote civil jury trial project. She is appearing remotely. She's not here in the courthouse. Special Magistrate Hodak's duties and responsibilities will be to oversee the remote bailiffs and ensure that our remote courtroom trial procedures are being followed. However, Special Magistrate Hodak cannot answer any questions about this case. Only I can answer your questions about the case. I've already used the term plaintiff and defendant to describe the parties involved in this lawsuit. A party who files a lawsuit is called the plaintiff. A party that is sued is called the defendant. The plaintiff in this case is appearing remotely and represented by counsel who is also appearing remotely. The attorney on your screen with the phrase plaintiff attorney represents the plaintiff who is the party who filed the lawsuit in this case. His job is to present the plaintiff's side of things to you, and as an attorney, he has taken an oath to do his very best and follow the rules for his profession. At this time, I would ask plaintiff's counsel, Mr. Kaczurgas, to introduce himself, as well as his client, who appears on your screen with the word plaintiff.
Good afternoon, ladies and gentlemen. My name is Matthew Kaczurgas, and I'm counsel for plaintiff Cayla Griffin, who at least on my screen is over in the top left corner. And I want to thank everyone for their appearance here in this rather unusual set of circumstances and rather unusual proceedings.
All right, thank you, Mr. Kaczurgas. The defendant, Albanese Enterprise, Inc., doing business as Paradise, has exercised its right to elect not to participate in this trial. You've already met Brian Corrigan, who is one of our deputy clerks who confirmed your identification and swore you in earlier this afternoon. There are going to be 2 other persons appearing on your screen with the label trial clerk. They are Nate Rogerson and Diana Irizarry. They're appearing on your screen now. You'll see that label clerk on the screen. They are our deputy clerks of court, and they are going to be serving during the course of this trial. They're here to assist me with some of the mechanics of the trial process, including numbering and collection of the exhibits that are introduced as evidence during the course of the trial. One of these trial clerks may be swearing in the witnesses, or the court may be swearing in the witnesses who appeared during the trial. The person sitting at the stenographic machine who will be appearing on your screen momentarily, there she is our remote court reporter, Stephanie Shear. She is not in the courtroom either. She is appearing remotely, and her job is to keep an accurate record of everything we say or do during this trial, including the statements and comments made during jury selection by the attorneys and by me, as well as all of your comments and testimony as prospective jurors. Thank you, Ms. Shear. Before going further with introductions, I would like to take this opportunity to make sure that you are aware that when you respond to questions asked during jury selection, we need you to give a verbal response, a yes or a no or some explanation. Please pause before you speak to allow us to finish our question or our comment so that we don't have people talking over each other during the process, because that can be problematic for the court reporter. Also, in normal conversation, you nod your head like this, or you nod your head like that, or you make a grunt or a groan, or some type of nonverbal signal to communicate with your friends, family, coworkers. That's acceptable in other circumstances, but in here, we need you to respond verbally with some verbal response, a yes or no or an explanation, because we don't want the court reporter to be in a position of having to interpret what your nonverbal response is. In addition, there may be a time during today's proceedings where one of us asks you to restate your answer. Please don't take offense at that. With the limits of technology and doing this remotely, there may be times where we have difficulty hearing you. And so please don't be offended if we ask you to repeat your answer. The court reporter may ask you as well, but please don't get offended. The persons who are about to appear on your screen with the title bailiff or remote bailiff are Mike Smith, James Muse, and Patrick Estelila. You see them appearing on the screen now. Each one of them are remote bailiffs. They do each have slightly different responsibilities. Mr. Smith is a remote trial bailiff for this trial, and as a remote trial bailiff, he is really in charge of keeping things running orderly and securely in the remote courtroom as it concerns the technology, the connections, the Zoom platform. He's really running the remote courtroom. And then we have Mr. Muse, who's dedicated entirely to the jury. So he's what I call a remote jury bailiff. His focus is entirely on your needs as our jurors, making sure that not only are you taken care of, but also that your technology works correctly as well. So anything that you need, Mr. Muse and our special magistrate, Ms. Hodak, are there to help. Mr. Estelila is kind of a crossover. He can cover both sides of the remote bailiff spectrum. He can help out Mr. Smith with the remote trial responsibilities. He can also help out Mr. Muse with the remote jury responsibilities. So he's wearing both hats. And I know you've already met all of them earlier today. They are also my representatives to the jury. They are my eyes and ears along with Ms. Hodak. They can see and hear you, their extra set of eyes and ears to see if any of you have a problem, if any of you all have a need. They can communicate those things to you. As I said earlier, they are also court technology officers, the very best court technology office in the state of Florida. Among all of our court technology officers, they are the very best in the state of Florida. So they are uniquely qualified to help you with any technology issues, anything at all that you need help with from a technology standpoint. They're very well qualified to do so, and so they'll take care of you. If you do have a problem, get their attention. Raise your hand, make an audible sound, anything at all, we can take care of it. Last but not least, there is the remote jury, which we will begin to select in a few moments from among all of you, as well as the other panels that have already appeared before you. The remote jury's job is to decide what the facts are and what the facts mean. Jurors should be as neutral as possible at this point and have no fixed opinion about the lawsuit. In order to have a fair and lawful trial, there are rules that all jurors must follow. A basic rule is that jurors must decide the case only on the evidence presented in this remote courtroom. You must not communicate or talk with anyone, including your fellow jurors, friends, family members, or coworkers about this case or anything having to do with this trial, the people and places involved in this trial, or your remote jury service. You must not disclose your thoughts about this case or ask for advice on how to decide this case. I want to stress that this rule means you must not use your electronic devices or computers to communicate with anyone about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages to or from anyone about this case or your jury service. Also, please do not invite anyone into your remote location where you're at right now to watch this remote jury selection or the remote trial with you. You must participate in these proceedings alone. I don't want anyone else in the room with you to observe. You must not do any research or look up any words, names, maps, photographs, anything at all that might have anything to do with this case. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the remote courthouse, at home, in recess, or anywhere else. Doesn't matter when or where it is until you're discharged from your service. These rules apply to you. What are the reasons for all these rules that I've given you? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in this remote courtroom. If you on your own go out and investigate, research, or make inquiries on your own outside of the remote courtroom, the trial judge has no way to make sure that the information you obtain is proper for this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find in your independent investigation. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. All of your communications with the remote courtroom personnel or me will be part of the record of these proceedings. What that means is that those communications shall have to either be made in open remote court with the court reporter present, or if they are in writing, the writing will be filed with the remote court clerk. I have instructed the remote courtroom personnel that any communications you have with them outside of my presence must be reported to me, and I will tell the parties and their attorneys about any communication from you that I believe may be of interest to them. However, you may communicate directly with remote courtroom personnel about matters concerning comfort and safety, your schedule, logistics, any problems you're having with Zoom, problems with technology, connection issues, internet issues, things as simple as what you should be allowed to wear in the remote courtroom, things of that nature. That's perfectly acceptable, and that does not have to take place on the record. However, if you become aware of any violation of these instructions that I've given you, or any other instruction in this case, you must tell me by sending a written note to the remote bailiff or special magistrate using the private Zoom chat message feature. After each recess, please double check to make sure that your cell phone or other electronic device not being used by you to participate in this remote jury selection is turned completely off. Also, please make sure that you do not bring your cell phone or other electronic device not being used by you to participate in this remote jury selection into the remote courtroom, or if you're selected to serve on the remote jury once the remote trial begins. We don't want any of those devices with you to distract you. They need to be out of sight and out of mind. Next, I want to give you an overview or explanation of how the jury selection process works so you might have a better idea of what to expect. As I said earlier, Mr. Kaczurgas and his client are going to select 8 jurors from among your panel and the other 3 panels to hear this case. At the start of jury selection, I'm going to read a general description of the case, including the names of potential remote witnesses and participants. I will ask you a series of questions about your knowledge of the facts, witnesses, and participants. Each of you should have already responded to the written online questionnaire. We did receive that back from you, and we do appreciate you doing that. That's going to save us some time because Mr. Kaczurgas and the court already have your basic background information that ordinarily would have to be handled verbally here in open court. So we already have all of that. So then after that, Mr. Kaczurgas is going to have an opportunity to ask you some more specific questions about the case to determine whether or not you can be fair and impartial to all sides given the issues that are involved. I will then meet with Mr. Kaczurgas and his client to select the 8 jurors that will serve in this case. And that process is one that takes a little bit of time to do. Mr. Kaczurgas will be allowed to exercise cause challenges to challenge you in terms of whether there's a problem with your ability to be fair and impartial. He could also exercise what are called peremptory challenges, which can be exercised for any reason at all. That back and forth usually takes a little bit of time to do, and sometime this afternoon we'll know who our 8 jurors are. As I stated earlier, I'm going to ask you a series of questions about your knowledge of the factual allegations of the case and the participants. So listen very closely. I'm about to give you and read to you a very general description and overview of what the case is about before I ask you a series of questions. So listen closely. This case involves plaintiff Cayla Griffin seeking damages against her former employer, defendant Albanese Enterprise, Inc., DBA Paradise, for injuries she suffered at the hands of two other employees of the establishment, Marcus Brewski and George Malcolm. On February 26, 2018, Ms. Griffin was beaten by the two men as she attempted to retrieve her belongings from inside. Ms. Griffin filed suit against Albanese Enterprise, Inc., DBA Paradise, alleging a claim of battery based upon Mr. Malcolm and Mr. Brewski intentionally and unlawfully striking Ms. Griffin against her will and without legal justification. The court has already determined that the defendant, Albanese Enterprise, Inc., DBA, or doing business as Paradise, is liable for the battery committed against Ms. Griffin by its employees, Mr. Malcolm and Mr. Brewski. Your job is to determine the amount of damages Ms. Griffin is entitled to for compensation for the injuries she suffered. Ms. Griffin is seeking damages for the injuries she suffered, medical and dental expenses, pain and suffering, mental anguish, and emotional distress. Hearing that very brief general description of the case, I need you to unmute your microphones at this time. Do any of you have any knowledge about this incident or this case prior to hearing that description today?
No, sir.
No, sir.
I seen it on News for Jack the other day.
Okay, you saw that as a coverage of the remote jury trial process? Ms.
Right.
Johnson, okay. All right. Anything other than that, Ms. Johnson?
No.
Okay. Mr. Pearson, do you have any knowledge of it prior to hearing my description today? You need to unmute your microphone, Mr. Pearson. I do the same thing all the time.
Sorry about that.
That's okay.
No, I've never heard of any of that.
Okay.
Sure.
And Ms. Schofield, you didn't know anything about it before hearing that description?
No, sir.
All right. And Ms. Jackson, you didn't know anything about before hearing the description?
No, sir.
And Ms. Maher, you didn't know anything about before hearing the description?
No, sir.
Ms. Maher, I saw at least a blur or a glimpse and a sound of a dog in the background. That happens sometimes. Is everything okay?
Yes, I apologize. Anytime anyone goes by.
It's okay. I believe me, I've seen all kinds of things doing hearings remotely by Zoom and by phone since mid-March. I've seen children and pets and all kinds of things going on, and that's to be expected. I just want to make sure we didn't need to take a moment for you to tend to anything.
No, everything's
Okay,
okay.
very
Thank
good
you.
then. And so, Ms. Johnson, seeing that news coverage about the case, does that in any way influence or affect your ability to be fair and impartial in this case?
No.
Right. Do you believe you'd be able to set aside whatever you heard in that or saw in that news story preceding your appearance today, the news story about the coverage about this being a remote civil jury trial? Can you set that aside and base your decision in this case based solely on the evidence and the instructions that I give you?
Yes.
All right. Thank you.
You're welcome.
I also have a series of other questions, so you can leave your microphones unmuted because I'm going to need you to give me a yes or no response. Earlier, the attorney trying the case introduced himself to you, Mr. Kaczurgas. Do any of you personally know Mr. Kaczurgas, the trial attorney in this case? Yes or no?
No.
No.
Yes.
All right. I believe I heard a yes from Ms. Maher. Do you know Mr. Kaczurgas?
Yes, I do.
Okay. And did Ms. Jackson, Ms. Schofield, did you know Mr. Kaczurgas?
No, sir.
No, sir.
Okay. Ms. Maher, how do you know Mr. Kaczurgas? Ms. Maher, how do you know Mr. Kaczurgas?
I know him socially from.
Okay.
Yes.
All right, very good then. All right, so let the record reflect that only Ms. Maher knew Mr. Kaczurgas. And also the same question for his client, Ms. Griffin. Do any of you feel like that you know Ms. Griffin, who was introduced to you earlier? She is a plaintiff in this case, Mr. Kaczurgas' client. Yes or no? Anyone know the plaintiff, Ms. Griffin?
No.
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 All right,
No,
let's,
sir.
all right. Did anyone answer differently in majority? It sounds like everyone answered no, but if anyone had a different answer, please raise your hand. Let the record reflect that all of our jurors have answered no as to knowledge of the plaintiff. Also, there will be witnesses who testify. In addition to Ms. Griffin, the plaintiff will also have the possibility of another witness, Charlie Griffin. Do any of you think that or believe that you may know a witness by the name of Charlie Griffin?
No.
No.
All right, sounds like everyone answered no to that question. If anyone answered differently in the majority, please raise your hand. All right, let the record reflect that no one is indicating knowledge of the witness, Charlie Griffin. You were also introduced to all the court personnel a few minutes ago. Do any of you know any of the court personnel in this case? That includes myself. It includes the other court personnel that are introduced to you, not Mr. Kaczurgis and his client, but the court personnel. Anyone here feel like they know any of the court personnel, yes or no?
No,
No.
sir.
Right.
No, sir.
It sounds like everyone answered no on that. And if anyone had a different answer that was different than the majority, please raise your hand. All right, let the record reflect that all of our jurors have answered no to any knowledge of the court, of the participants and the court personnel. And now I'm going to talk to you about the next stage, which is where Mr. Kaczurgis, as plaintiff's counsel, has an opportunity to ask you some questions. So this next phase is going to provide Mr. Kaczurgis an opportunity to ask you more specific questions that have been asked so far about the issues that may be relevant to this case in order to help him come to his own conclusions about your ability to be fair and impartial. After he has asked all of his questions of this jury panel and we have completed all the other jury panels, I'm then going to meet with him and his client to pick the jurors as I discussed earlier. And after all those challenges for cause and peremptory strikes are exercised, we'll have a final jury of 8 persons to hear this case and make a decision. And so I want to tell you in advance that only 8 of you can serve, and we have to take into account we have 3 other panels that were heard before yours. So from a number standpoint, with 40 plus jurors having appeared over the course of yesterday and today, the numbers are such that more likely than not, you'll be excused from jury service. So if you do get that email saying that you're discharged and that you were not selected to serve as a juror and your service is completed, please don't take that personally and don't consider it to be an insult or any negative reflection on you, and do not feel offended or feel that your integrity or honesty are being questioned, because they are not. It could be that the numbers are such that there was no way we could get to you, or it could be that you were excused for some other reason. But regardless of why, you don't need to know the why. If you're excused from serving, it doesn't mean that anything negative towards you. And so the questions that are going to be asked by Mr. Kaczurgis are not intended to embarrass you or unnecessarily pry into your personal affairs, but it is important that the plaintiff and her attorney know enough about you to make this very important decision of who's going to sit on the jury in this case. If a question is asked of you that you prefer not to answer in front of the rest of your fellow jurors and those that are observing and watching, just let me know, and I'll allow you to give your answer outside the presence of everyone else. I'll go to the remote sidebar where it will just be yourself, the court reporter, and Mr. Kaczurgis, and then you can answer the question. But I'm going to ask you to use your discretion when taking advantage of that option to do things, answer your questions away from your fellow jurors, because if everyone takes that option to do that, it'll take a very long time to get through jury selection if we have to go one by one in the remote sidebar. So please use your discretion on that. There are no right or wrong answers to the questions that are going to be asked of you. The only thing I'm going to ask is that you answer the questions as frankly and honestly and as completely as you possibly can. You have taken an oath to answer all the questions truthfully and completely, and you must do so. Remaining silent when you have information you should disclose is a violation of that oath as well. If a juror violates this oath, it not only may result in having to try the case all over again, but also can result in civil and criminal penalties against the juror personally. So again, it is very important that you be as honest and complete with your answers as you possibly can. If you don't understand a question, please raise your hand and ask for an explanation or clarification. In summary, this process is going to assist Mr. Kaczurgis and his client to select jurors that can be fair and impartial in this case. In order to have a fair and impartial jury, the law does not require that each juror have absolutely no opinions or biases before they can be selected to serve. All of us have opinions. All of us have biases, whether we like it or not. We all walk around every day with all those things that we have that are inherent to us. We can't change that. The law simply requires that a juror be able to set aside any opinions and biases that he or she may have and decide this case based solely on the law that I instruct you in and the evidence that you will receive through the testimony presented during the trial and the exhibits. All the questions the attorney is going to ask you are for this purpose and this purpose alone. If for any reason you do not think you can be fair and impartial as a juror, please tell us. And that includes something that may not be responsive to Mr. Kaczurgis's questions. So he's very thorough and he's very comprehensive. I'm sure he'll cover all the bases, but if for some reason he misses one or if I missed one, please, before we close out here this afternoon, please let us know of any reason why you feel like you can't be fair and impartial. Please remember that all the rules I've given you apply even when you're outside the remote courtroom, such as at recess. Now, at this time, Mr. Kaczurgis, as the attorney for the plaintiff, will ask you questions remotely. Please remember that what Mr. Kaczurgis says now or any other time during the trial is not to be accepted by you as evidence or law. In fact, he is not allowed to tell you what the law is. That is the sole job of the court. Mr. Kaczurgis will simply be asking you questions and looking for answers from you. Do not infer anything or read anything into his questions that he asks you. At this time, Mr. Kaczurgis, would you like to inquire of this jury panel?
Yes, Your Honor.
All right, you may inquire.
Good afternoon, ladies and gentlemen. As I previously introduced myself, my name is Matt Kaczurgis, and I'm representing plaintiff Cayla Griffin in this case. What this portion of the proceedings are called is voir dire. And what that is a French term that translates to speak the truth. And the purpose of voir dire is to find out, as Judge Anderson had alluded to, whether people have opinions or feelings about topics related to the case that may affect their view or understanding and deliberations of the case. To give the litigants in any cause more information about making selections about jurors that would help analyze the case. And as Judge Anderson alluded to, it's quite all right to have opinions and biases. We all have them. Over the course of one's life experience, you gather this material and it affects the way you view the world. That's just the way we all operate. The good part about this is there is absolutely no right or wrong answer to any of this. It's just questions and answers about our life experiences and how we view the world. As I said, there is no right or wrong answer. And so all we ask is that you be completely candid with us about your views on certain topics and your background and experience. As Judge Anderson also alluded to, the questionnaires that you were kind enough to fill out prior to reporting the service for today have also been furnished to counsel, and I've had the benefit of reviewing those, and I may have some questions and follow up to that, as well as some questions relating to certain aspects of the case that we want to find out about, whether that would affect your view of these proceedings. So with that being said, what I'm going to do is start reviewing some of the questionnaires and ask these questions, and I'm going to take them in the order by which you've been assigned juror numbers. And the first one that I've got for this panel this afternoon is juror number 76, Ms. Jackson. Ms. Jackson, there you are. Good afternoon.
Hi, good afternoon.
And I see that you live in the White House area. Is that correct?
Yes, sir. I just actually recently moved, but my address is still there. I haven't changed anything. It's very recent, so.
Okay, yeah. No one's here examining whether you've updated your driver's license within the required 10 days. Don't worry about any of that stuff. May I ask where you
Mr.
recently moved?
Kaczurgis, I hate to interrupt, but I had a quick question, and I meant to do this before I turned it over to you, but we've been going for over an hour, and I'm going to inquire of the jury at this point. Does anyone feel like that you all need a comfort break for any reason? I normally don't go that long without a comfort break, and I know we had a little recess at the beginning for me to inquire of 3 of your fellow jurors, but is everyone comfortable right now? Does anyone feel like they need a comfort break for any reason or need to get up and move? If so, raise your hand, let me know, and we'll take a comfort break. Anyone at all? Mr. Ashley, can we switch that to gallery view? Thank you. All right, anyone feel like they need a break? Any of our jurors at all? All right, everyone's good? All right, very good then. I'm sorry to interrupt, Mr. Kaczurgas, you may proceed.
All right. I think we left off, Ms. Jackson, with where have you recently moved to?
I just moved to the south side area.
Okay. And I noted from your questionnaire you had lived in the White House area for 20 years. Is it safe to assume that was with your parents, given your age?
Yes, yes, sir.
Okay. And I understand you're a teacher, and I'm going to ask you a couple of questions because it's more of a reflection of my ignorance than it is your response. I see you're a teacher at Ridgeview High School. That's here in Jacksonville?
It's Orange Park, Florida, actually.
Thank you. And it's an ASD teacher. I have to confess, I'm not familiar with that. What is that?
Autism spectrum disorder.
Oh, very, very good. Thank you for doing that work. How long have you been doing that?
Last year was my first year.
Okay. And reporting back to duty here in the next 10 days or so?
Yes, we start back on Tuesday.
Okay. Would that pose a problem with you in service in this case? As Judge Anderson stated, we're anticipating wrapping up Monday, but there's a remote chance that this may bleed into Tuesday morning. Would that pose a problem for you in reporting back to work?
It wouldn't be a problem. It would just be more of an inconvenience. I'd have to get information from other people that were at school on Tuesday.
Okay. As he also said, we're getting towards the end of the jury panel, so there's a high likelihood that we won't get to you. So I think you'll be okay.
Okay.
20 years in the area, that means you're more or less a Jacksonville girl, right?
Yes, I was born in Ohio, but I moved here when I was 2 years old.
Got it. Where'd you go to high school?
Trinity Christian Academy,
Okay. How about college?
University of North Florida.
In terms of some issues in the case, as Judge Anderson alluded to, the case involved an allegation of battery. Have you ever been in any fights, physical confrontations, been the victim of domestic abuse, any of that? And as he said, if we're touching on sensitive subjects, feel free, if you're uncomfortable answering them in this forum, we can take you at sidebar. But I need to explore a couple issues relating to the case, and one of which is experience with acts of violence. Have you ever been exposed to that, or any of your loved ones?
No, sir.
And as you may have been able to tell from his description of the case, the defendant in this case is an entity called Albanese Enterprises, Inc., DBA, and that's a legal term for doing business as Paradise. To put a finer point on that, it is Paradise Gentlemen's Club. Does the fact that this case involves events taking place at a gentleman's club, do you have any feelings or opinions about that type of a business?
No.
Okay. Have you ever worked at one?
No.
Have you ever been to one?
Yes.
Okay. Would the fact that you've been to one of those establishments and been in there, would that affect in any way your view of the evidence in this case, or cause you to view one side more favorably than the other?
No.
Tangentially, there may be issues in the case relating to alcohol consumption. Have you or any of your loved ones, family members, close friends, not mere acquaintances, but friends, ever had any issues with alcohol? And I don't mean having drinks, but more significant issues.
No, other than a few addictions in the family, extended family, but other than that, no.
Yeah, and modern America, you're not alone in that regard. Would those issues with any of your loved ones, would that in any way affect your view of the evidence or any of the issues in this case? Do you have any inherent biases relating to that issue?
No, sir.
Okay. Another aspect of the case. This is what we call in the legal environment a damages trial. As Judge Anderson has stated, that the defendant, Albanese Enterprises, Inc., has already been determined liable in the case. So what this jury is going to be tasked to do is determine the amount of damages to be awarded to Ms. Griffin. And in that setting, in the damages portion of a trial, there's generally two types of damages that can be sought. One of which is economic, or what we call hard damages. Damages for which you can produce receipts, bills, medical expenses, out-of-pocket expenses for receipts, if it's a claim for lost wages, lost income, but things you can put a hard dollar figure on and associate with receipts or bills. There's another aspect of cases called non-economic damages, and those encompass such things as pain and suffering, mental anguish, and emotional distress. Do you have any feelings or opinions, one, about lawsuits in general? For instance, do you believe that people in America these days are too eager to file lawsuits?
I would say sometimes, yes.
Okay. And is there any particular aspect of your background that caused you to form that opinion, or is that just an opinion you've come to over your young life here on this planet?
Just an opinion of mine, yeah, that I've come
No, it's
to.
fair enough. As I said, there is no right or wrong answers here this afternoon. So do you have a problem, and this is more of a theoretical question, but do you have a view or feelings, opinions about the awarding of non-economic damages that you can't put a precise price tag on? Do you have any issues with that?
I guess a little bit I would.
Okay. And what would be the feelings or issues that you have with that?
Just I'm not sure, like the things that you can't put a price on, like I would want to know if they say, okay, I need to go to therapy, you know, because I have emotional damage, I need to go to therapy, and there's no really price on that. It's not like a bill, here's my medical bill for this surgery, what have you. I would want to see, you know, how much were you going to, evidence that you've been going to therapy, something like that, if that makes sense.
It's a good point. Now, let me put a different spin on it. If you sat through the trial and you sat through the evidence and you thought that the evidence presented by plaintiff, and in this case, we're dealing with a preponderance of evidence standard, more likely than not, in law school, they teach you it's 51%, but more likely than not, if the plaintiff put on sufficient evidence to meet that standard, the preponderance, and put on the preponderance of evidence that you believe she did have actual pain and suffering, would you be able to come to or reach an agreement or be able to award her damages for such things as pain and suffering?
Yes, I think so. Mm-hmm.
Likewise, mental anguish and emotional distress. If you felt that the plaintiff met her burden of persuasion on that and the greater weight of evidence supported that she did suffer mental anguish or emotional distress, do you think you would be able to reasonably approximate some value of what that damage was?
Yes, I would think so, based on evidence and things that I hear and see.
Okay. So even though it's fuzzy, you think you could arrive at some estimate as to what a value would be?
I think so. Mm-hmm.
Yeah. Thank you. Thank you, Ms. Jackson. I may circle back to you with some stuff a little later. And I forget, I think Ms. Johnson was the one that had seen some pretrial publicity about the case. Had you seen anything about this case before reporting this afternoon?
No, I have not.
Okay. Thank you, Ms. Jackson.
Thank you.
Ms. Johnson, if we could talk with you for a second.
Mr. Gutierrez, let's take a moment right here. Mr. Pearson, juror number 84, are you okay? You can unmute your microphone, sir. Mr. Pearson, while Mr. Gutierrez was questioning Ms. Jackson, I noticed that you changed location, which is fine. If wherever you need to be, that's fine.
Well, my cell phone was almost dead. It doesn't last as long as it used to. And so
Okay.
I had to come in the bedroom and plug it in.
That's fine. That's fine. I just noticed that you were more in a reclining position, which I know may be more comfortable. I was
Wow, you don't miss much.
I'm trying to keep my eye on everyone, but I was worried that you might be getting a little too
No.
comfortable. We might end up with you being asleep at some point. So,
No. How do you remember all this stuff?
well, that's why they pay. That's why they pay me the big bucks, I should say.
Ah,
But what I was
I'm
going to
sorry.
say is that maybe it might be easier for you if I know there's a plug-in right there. Maybe there's a way for you to set up more in bed where you're not totally reclining, and then you could maybe see the phone and have it charging or plugged in and not look like you're falling asleep.
I think I'm okay now here.
Okay.
There's not even one outlet available in
Okay.
that room, the
All
other
right.
room where I was in initially.
Okay. I just want to make sure you're still with us.
I am, I promise.
All right. Very good then. All right.
Thank you, sir.
Thank you, sir. You may proceed, Mr. Kaczurgas.
Thank you, Your Honor. Ms. Johnson, juror 79. How you doing this afternoon?
I'm fine. How are you?
I'm doing well. I'm all right. Let me start with you had shared with the court that you did see some pretrial publicity about this case before reporting today. I think you stated it was a News for Jack's piece. Was that on the TV or digitally consumed?
No, I've seen it on News for Jacks on my phone.
On your phone? Was there anything about the reporting of this that causes any feelings or issues for you?
No.
Okay, so whatever news coverage you saw doesn't affect your ability to serve as an fair and impartial juror in this case?
No, not at all.
Thanks. I see you have lived on the west side of Jacksonville for the past 6 years. Is that right?
Yes. Mm-hmm.
Where on the west side are you living?
Off of 103rd Street.
Got it. And prior to that, on the north side, may I ask the same question? Where on the north side you had resided?
Off of Lem Turner.
Okay. And according to the questionnaire, you're in the customer service field. May I ask for whom you work?
Yes, I work for a mortgage company.
Okay. And so I understand from some reporting over the COVID era, the mortgage industry may be one of those that are doing better than others in terms of the economy with COVID. Glad to hear that you're still working there. I see you have 3 children. Can I ask what the breakdown is between boys and girls with those children?
I have 2 girls, 1 boy.
Okay. And I know we got school starting up here in about roughly 10 days, a little over a week. Does the imminent report to school date pose any issues for you in terms of hardships and getting the kids geared up to go back to school, or are you able to handle jury service and manage that as well?
I mean, it may be kind of hard because I'm working from home and then trying to take care of that as well.
Okay. If push came to shove, do you think you could do it, or is it too much to juggle?
No, I would be able to do it because most of the school issues, because I'm working at home, I have to do on the weekends anyway, because I work 9 to 6.
Okay. Let me, in the same vein that I was speaking with Ms. Jackson about, let me ask you some questions here. Do you have any past experiences, either yourself, close family, close friends, with history of violence, domestic abuse, physical altercations? Do you have any of that informs your background?
No.
Okay. Likewise, one of the issues in this case is that it centers around events at a gentleman's club. Is there anything about that aspect of the case that you have feelings or opinions about that would affect your views of it before we even present evidence?
No.
No. Have you ever worked at a gentleman's club?
No.
You ever been to one?
Yes.
Okay. Anything about your experiences there that would affect your view of the case or any of the issues in it?
No.
Likewise, tangentially, alcohol may be present as a factor of evidence in this case. Do yourself, close family, close friends, anybody in your background have any issues with alcohol?
No, not at all.
Okay, so that wouldn't affect your deliberations in this case?
No.
Do you drink?
Occasionally.
Okay, socially?
It's only wine though.
Okay. You're a red wine drinker or a white wine drinker?
It's peach flavor, so.
Turning to the issue of damages, and I've kind of given an explanation, and so I hope not to repeat it to everybody, but do you take any issue with the number of lawsuits in America? Do you think that people are too eager to file lawsuits?
I do.
Okay. May I ask why you have that opinion?
Because with this economy, a lot of people need money, so I feel like they try, if it's something that they feel that they can get money off of, then they're going to do it.
Okay. Do you see that as a recent event with COVID, or do you think that existed prior to the COVID pandemic?
No, I think it's already been pre-existed before the COVID.
Yeah. Do you have any issue with awarding non-economic damages, pain and suffering, mental anguish? If the evidence supported such an award, even though they don't have receipts or bills, do you take any issue with awarding those measure of damages?
No, because I feel like if you went through that and you experienced that, then you should be able to be accommodated for what you went through.
Even though there may not be a receipt with a dollar value on it, you think you could approximate a value if the evidence supported it?
Yes.
Okay. Ms. Johnson, from what source do you consume your news?
Either from the TV or my cell phone.
And do you have any go-to channels on your cell phone or TV that you take in for news coverage?
The only news that I watch is News for Jax. Or
Keep it local. You keep your coverage local, huh?
I don't. CNN is a little too deep for me, so.
Okay. Thank you, Ms. Johnson.
You're welcome.
Next, we have juror number 80, Ms. Maher. Good afternoon. You might want to unmute yourself.
Hi.
All right. How are you doing this afternoon?
How are you?
I'm doing well, but I'm having a hard time hearing you, Ms. Maher. I don't know if it's your distance from the microphone or if we need to turn up the volume on it.
Is that better?
Yes, a little bit.
It's a little better, but let me ask our court reporter, Madam Court Reporter, are you able to hear her okay? I'm having a strain to hear Ms. Maher. Can you hear her?
It's very low.
It's very low. So Ms. Maher, can we increase the volume some more?
Turned it up all the way. Can you hear me better now?
I can hear you better now. And Madam Court Reporter, is that going to be acceptable?
Yes, sir.
All right. Thank you, Madam Court Reporter. I think we're fine now if you can keep it at that level, Ms. Maher.
Okay.
And I regret having to force you into the microphone because I know no one likes staring into the camera at point blank range, but we're all doing the best we can under the circumstances. Yeah. Indeed, this is very strange for me. I'm a people person. I'm used to being in the courtroom, eyeball to eyeball. I'm a hugger. I'm a handshaker. And so we're all doing the best we can with this. Ms. Maher, it didn't go without anyone's notice. I don't think that you and I know one another.
Yeah.
Ms. Maher, we're not hearing you. You're
We do know one another. I apologize.
okay.
And you're on a laptop, right?
Yes.
Is there anything covering up the microphone, or do you know where that is on that?
I don't think there's covering. I don't know.
Okay, it's a little better there.
Oh, if I pull it, is that better?
Yeah, a little bit.
Okay.
Yeah, fair. I think we're working now.
Okay.
Is the fact that I'm the attorney for plaintiff and I'm going to be asking the jury to return an award of significant monetary damages, would your relationship with me affect in any way your decision whether to award damages to plaintiff or not?
No,
Despite our relationship, for lack of a better term, and knowledge of one another, despite that, you would treat this case fairly and evaluate it on the evidence and the evidence alone?
yes, for sure.
Okay. Put another way, despite my involvement in the case, you would nevertheless be able to be a fair and impartial juror.
Yes,
Is that okay?
of course.
And I know you live at the beach, and you've done so for 15 years. Prior to that, you lived in Miami. Was that you a Miami girl born and raised?
No, I was born in Michigan, grew up in Jacksonville most of my life until I was in college, and I went to school in Miami
Okay.
at FIU.
And I know what you do for a living. And let me turn to the questions about the aspects of this case. Do you have any experience in your background involving violence, physical altercations, or domestic abuse that you bring into the table before we even get into the presentation of evidence?
I was mugged in Miami.
I'm sorry to hear that.
Yeah. Physically attacked, basically. And then my family was kind of dysfunctional, but not really violent. My brothers maybe to one another, but nothing that would pertain to a case like this. Nothing.
Okay. Nothing out of the ordinary, just brotherly,
Nah, I mean,
mild violence.
it could be intense.
Okay.
Yeah.
But, and I think you've just hit on it. Those experiences wouldn't have any effect upon your serving in this case?
No, I don't think it's relative.
Okay. Even the fact that you were physically assaulted during a mugging, do you think you could put that aside and serve as a fair?
Yes, definitely.
Okay. Alcohol, any issues with you, family, close friends with alcohol coming into the case?
No, I mean, a lot of people drink. I myself quit drinking 6 months ago, so there you have
Well,
it.
good for you.
Thank
All right. Anything about your own experience or those of persons you know that would affect your view of the evidence or those types of issues?
No.
Okay. Gentlemen's clubs. Do you have any opinions or feelings about them?
I've been to one once, and no, I mean, I don't have any opinions or feelings about them.
I take from that response you've never worked at one.
No, I've never worked at one.
Okay. And you've been to one once?
Yes.
Right. Anything about that experience that brings you to the case with feelings or opinions about that environment that could affect your view of the evidence or deliberations in the case?
No, not at all.
How about damages? Do you think people are too litigious in America, too eager to file lawsuits?
Yes, I do.
Okay. Anything that specifically informs that opinion, or just watching TV and driving down I-95?
Basically those things.
Okay.
And hearing people, seek out damages for things constantly, it's just pervasive in our society, I think.
Okay. Despite that opinion or those beliefs, do you think you could put those aside and evaluate the merits of this case as to whether Miss Griffin suffered damages to the extent that she deserves an award from a jury to compensate her for her injuries?
Yes, I believe I could be fair.
Okay. Do you take any issue with people seeking non-economic damages, pain and suffering, emotional distress, mental anguish?
No, not at all.
Right. Put another way, if you believe that plaintiff presented sufficient evidence to support an award of such damages, you would be willing to do so?
Yes, I would.
And the fact that you don't have a receipt or a bill to put an exact monetary value on it, do you think you could come up with a reasonable approximation of value to make such an award?
Yes, I do.
Okay. You wouldn't provide just a token amount because of the inexact science of coming to a number?
No.
Thank you, Ms. Mayer.
You're welcome.
And if we could next speak to juror number 84, Mr. Pearson. I think you have to unmute your phone there.
At least I'm consistent.
Happens to the best of us. I think between the court and myself, we've had a number of those. I see from your questionnaire that you live in the Mandarin area of town.
Yes, sir.
And for the past 3 years and prior to that from White Springs, is that right?
Yes, sir. White Springs and Lake City.
I was going to ask. My recollection of that is it's in near Lake City. So thanks for clarifying.
It is.
And you're a hardwood floor contractor and a cell phone business. I know that that's tough work, and owning your own business is tough work. With the fact that you've got that going on, would participating in a trial interfere with your ability to serve as a juror in this case?
No, sir. I'm kind of semi-retired and I pick and choose what I want, but no, that'd be fine. I can rearrange my schedule if I need to.
Right. It's a good spot to be. And
I haven't worked in a while, so I'm not going out anywhere.
Well, you're not alone. A lot of people can say that since about March of this year. And I see you've got 3 adult children. What's the breakdown between them, boys and girls?
2 boys and 1 girl.
Okay, and what do they do for a living?
Well, my oldest daughter, Wendy, is a kind of a computer scientist. She's got a degree in computer, and she works with kind of a channel of lawyers that do things. She's kind of a, she types up all the letters and edits them for a number of lawyers in this one conglomerate.
Okay. Do you know what type of law the lawyer she works for practice?
I have no idea.
Okay. So that wouldn't affect your view of the evidence in this case then, would it?
No, sir. Not at all.
What about your second child? What does he or she do?
My second child, Aaron, works for a high-rise window washing company.
Oh,
Crazy.
Dangerous work.
Well, and anything else you want to know about him?
I don't think so. I think that covers it for him. How about your youngest?
My youngest baby, Jesse, he works for a scuba gear company as a builder and kind of a repairman for some elaborate scuba gear. If
Okay.
there's such a thing.
So he's
I'm
not
proud of
posted
him.
on a tropical island renting gear out to tourists, huh?
I don't think so.
Okay. And let me address some of the issues in this case with you. Do you have any issues in your past or your background relating to physical altercations, domestic abuse, violence, any of those things?
No, sir, nothing out of the ordinary.
Okay. Nothing that you come into this with prior experiences that affect your view of that topic?
I don't think so.
Okay. How about alcohol? Yourself, close family, close friends, anybody have issues with alcohol in your background?
Well, my father was a pretty bad alcoholic. He died some 20 years ago, and I guess this is going on for everybody to hear. My sister's still alive, and she's got a big problem with it. Other than that, that's all.
Yeah, and for what it's worth, I don't think you're alone. I can attest that I've had issues of a similar ilk. So, and anything about those experiences with your sister or your father that would affect your view of the evidence before even hearing it, if it related to alcohol?
I don't think so, no. I learned a lot what not to do.
Yep. Very good. And I'm sure your children appreciate that.
They do.
Yes. Gentlemen's clubs, you have any opinions or feelings about them?
No, it seems like everybody's been to one. I've been to one.
Okay. You ever work at one?
No.
Okay. You've been there, and I'm not going to ask you how many times, but did your attendance or being at one, does that in any way affect your view of events taking place there?
No. I felt a little guilty, but I got over it. No,
Okay. Damages. Do you think there's people in America are too eager to file lawsuits?
absolutely. I do.
Okay. And once again, there's no right or wrong answer here. This is exactly what this is designed to do. Does your opinion in that regard, and it sounds like your opinion may be a little bit stronger than some of the others, and that's fine. But would your opinion on that influence your ability to sit in judgment in a case where the function is to award damages from a lawsuit?
No, sir. I just listen to the facts and the evidence and take it from there.
Okay.
No,
So
not at all.
if you thought that the plaintiff met her burden of establishing by the greater weight of evidence that she was damaged and suffered pain and suffering or mental anguish, emotional distress, would you be willing to?
Would you say that again? I didn't understand what you were saying.
Okay, fair enough. Thank you. If the plaintiff put on evidence and met her burden of proof, greater weight of evidence, that she suffered pain, that she suffered from the assault that she was a victim of, and that she had pain and suffering and mental anguish, would you be willing to award those damages?
Yes, I don't think that sort of thing is acceptable in any way, for any reason.
And without hearing the evidence, but if the plaintiff presented sufficient evidence, would you be willing to provide an award, compensation for that sort of conduct that she suffered?
It would totally depend on the evidence presented to me, but if it was, yes,
Okay.
I could award.
Okay. Mr. Pearson, thank you. I appreciate it, and I appreciate your candor.
Yes, sir. Thank you.
And then lastly, this afternoon, we have Ms. Schofield. How are you doing?
I'm doing fine. How are you?
I'm doing well. And it appears you're appearing with us this afternoon from your home as well. Is that true?
Yes, sir.
And I can't help but notice you've got a gentleman in a hat kind of coming in and out behind you there. I'm going to make an
I'm
assumption.
sorry.
Oh, please
That's
don't
my
apologize.
husband.
No, please don't apologize. And so is there anything about appearing from home and having a husband wandering around, would that affect you in any way from serving as a juror?
No, sir.
Okay. Is he just a busybody that likes to walk around the house? And
Well, he comes from the shop and he was coming through the house, going to the garage, and vice versa. I'll
Well,
have to
sounds
tell
like
him
you're
if I
lucky.
get chose to go around the house.
Okay, well, it sounds like you're lucky to have a husband that works in the shop and likes to come in and out of the garage. You might get some things done around there.
I'm very fortunate, very blessed.
Good. You had talked with us earlier and had shared some issues about a possible hardship, and I'll be candid with you. I've never heard of burning mouth syndrome, but that sounds horrible. Are you okay?
It is, yeah, and as long as I'm taking my pain medicine, it doesn't burn. I had never heard of it before, but what it is the nerve endings inside my mouth and on my tongue and lips, they burn. It feels kind of like when you drink a real hot coffee and it scalds your mouth and tongue. Well, that's what it is, but sometimes it gets really painful. So I have to take my meds. If I don't take my meds, then it burns.
Well, my best wishes to you with that, because that does sound
Thank
good.
you. I hope it goes away. There's no cure for it. So I'm hoping sometimes I could get up in the morning and it'd be gone. And I've got our pastor's wife, I found out she's had it for 11 years.
And it doesn't go away.
No,
Oh,
it
I'm
could, but she's had it for 11 years.
Okay. Well, I hope your medication provides you some relief, though.
It does. It does.
Good. Anything about that you think that would interfere with your service as a juror in this case?
No, sir. I don't. If I had to go to the courthouse, it would interfere because I can't drive. If I move fast, it makes me real dizzy. So I have to, and I've gained weight because I don't move much.
Well, I'm gaining weight, and I don't know if it's because of that or just, getting to that time in my life,
Well.
Yeah.
While he's checking his notes, Ms. Schofield, has anything changed since I last asked you some questions about your medications and your condition? Are you still feeling like you're following along, not getting drowsy or sleepy?
No, sir. Everything's good.
Okay, good.
On your jury questionnaire that the court furnished to counsel, I see that you're retired. Can I ask you what you're retired from?
Well, I worked several jobs, but my last job, I was a truck driver, a semi-truck driver.
Long haul?
Yes, sir. We did it. Me and my husband did team for 10 and a half years.
Wow, that's some tight quarters for a couple, is it not?
Yeah, but we managed. This October we'll be married 50 years.
Congratulations.
So, thank you. But I enjoyed it. In fact, I had a harder time leaving it than he did, but my dad had lung cancer and his mother-in-law, stepmother had eye cancer. So we decided it was time to get off. So we got off the truck.
Got to see a lot of the country though, huh?
Yes, some of it was really pretty. Most of it was.
That's nice. And I see you've got 2 adult children as well?
Yes, sir. I have a boy and a girl.
Boy and a girl. And what do they do for a living?
My daughter works for an attorney downtown. She's in the old independent building. It's several attorneys. And my son is an engineer for Liberty Company down in Melbourne.
And what does Liberty Company do?
It interacts with veterans. It tries to set them up where they can get their medical records and stuff online. He writes computer programs for them. He worked for GE 19 years.
Okay. It sounds like he's currently, though, working for a veterans advocacy group.
I know that they're engaged with the VAs, all I can tell, veterans. So.
Yeah. And do you know the name of the law firm for which your daughter works?
I know one of them. I think one of the name is Balsey. Is it Balsey? It's several of them, and I can't remember them.
Is it one of those big firms?
Yes.
Okay.
Yes.
I think I know to which you refer. Let me ask you about these issues in this case. Do you have any experience or anything in your background as it relates to violence, physical altercations, domestic abuse, any of that stuff?
No, sir.
Okay. So that wouldn't affect anything in terms of your view of the case, would it?
No, sir.
How about alcohol? Either yourself, family, close friends, anybody got background with alcohol issues?
No, sir.
Okay. Lastly, gentlemen's clubs. Do you have an opinion one way or the other?
Well, I've never been in one. And I guess that's, an individual thing. If they decide to go, then that's what they've got to accept and whatever.
All right. I take it then you never worked at one.
Nope.
Okay. Do you have any bias or any opinions or feelings if for or against somebody that did work at one?
No, I wouldn't have. I mean, that's their, I feel like, and it's them. I mean, it's not me. Now, if it was one of my granddaughters, I'd probably have to say something.
Okay.
But if I, it's an individual thing, I feel like.
But you wouldn't hold it against or weigh in favor just because of that fact?
No.
Very good. How about damages? Let me ask the same question to you. You think there's too many lawsuits in this country?
Yes, sir, I do.
And is there any specific reason why you hold that opinion, or just what you see?
Well, I think the society that we're in now, people are very self-serving, and everybody is not taking responsibility for themselves and their problems and their faults.
And do you see as a symptom of that problem too many lawsuits?
Yes, I do.
Okay, very good. Turning to the specific question about the type of damages, do you have any feelings or opinions about non-economic damages, pain and suffering?
I don't know anything about the case. I feel like if the person was damaged and had to have medical help, I feel that they should be awarded for it.
For those non-economic damages?
Yes.
Okay. And likewise, mental anguish, emotional distress, if the evidence supported that occurred, you could compensate them?
Yes, I would.
And the fact that there isn't a bill or a receipt that makes it all tidy and neat, do you think that you could reasonably approximate a form of compensation?
Well, if there's no proof, that would be a hard one.
What if the proof?
Pardon?
What if the proof consisted of just the testimony of the plaintiff?
So many people complain a lot, and that would be a very tough one. I would have to hear the individual person, but I would think they would have to be proof that she's had, because if you have mental problems and you need to go to a psychologist or a therapist or something, then there should be some paperwork there.
That's what you want to see to support that award.
Yes.
Okay, fair enough. As I said, there is no right or wrong answers here this afternoon. Everybody gets an A+.
Okay.
Let me throw this one last kind of follow-up question out to everybody. We've talked about some issues in the case and about people's backgrounds here. Does anybody have anything that they think that they should put on the table for me that we haven't touched upon through questioning, that there's something in the background that you think I ought to know before picking a jury in the case that may affect my understanding of whether anyone has any bias? Anyone?
No.
I see no show of hands, so it looks like we've covered it. Ms. Johnson, did you have something to say?
No, I was saying no.
Okay. Your Honor, I've got nothing further this afternoon.
All right, thank you, Mr. Kaczurgis. Ladies and gentlemen of the jury, Mr. Kaczurgis has completed his questioning, and I'm about to send you off for your recess today. I want to tell you that you all have been a wonderful jury panel. Between the two panels yesterday and the two panels today, I couldn't have asked for a better group of 40-something jurors to have my first interaction with jurors since the end of February. It has really been a joy and a pleasure to meet each one of you and to spend time with you all this afternoon in this very important process. I do have some very important instructions to give you. So these instructions are going to be given to you because, as I said earlier, I don't know if you're going to be on the jury or not. So I'm going to treat you the same way I would if you were actually on the jury and going into recess for the evening. So listen very closely and follow these instructions carefully. Each of you are going to receive an email from our remote bailiffs sometime this afternoon. I don't know if it's going to be within the next hour, hour and a half, 2 hours, 2.5 hours. Sometime this afternoon, you're going to get an email from our remote bailiffs. And that email is going to be one of two versions. You're going to get one version that says, that you've been selected to serve as one of our 8 trial jurors and you'll have detailed instructions on how to log in using Zoom on Monday morning. You'll receive instructions on a virtual background and so forth. And we'll be starting trial on Monday morning. Same way we've been doing it today. You'll be remote. You won't have to leave your location. You'll use your device again and join us remotely. Or in the alternative, you're going to receive an email that says that you are not selected to serve, thanking you for your time and your service. It'll contain detailed instructions on how to obtain a return to work letter or written excuse for your employer, or a written excuse for your school or for your professor or teacher if you're a student, or to provide some type of written explanation to your significant other about where you've been all afternoon on a Friday when the courthouse is closed to in-person jury trials. That'll be your letter to show your significant other where you've been today. So with all that being said, there's one if you don't remember anything else I've just said, I want you to remember the following. If you're not selected to serve as a juror in this case, your email will say all those things I just said, but most importantly, there will be a link to a survey. That survey is important. It's something that the Florida Supreme Court needs. It's something that we need to decide how we're going to proceed with this project in the future. And so if you don't remember anything I've just said, I want you to remember the survey. Remember, click on that link, go to the survey and answer the question, because your input is very important to us going forward with this project. We need your input to decide what to improve upon, what to do differently, what to do better, what can stay the same. These are all things that we need to know as we move forward. So I really need you to answer that survey as soon as possible. So, because I don't know whether or not you're going to be on the jury in this case, please listen to the following instructions. Don't attempt to do any investigation or research about this case. Don't attempt to go to the scene or location of the incident or anything that you've learned about, or research anything you've learned about during the course of the jury selection. All the instructions I gave you earlier today, they remain in full force and effect. Don't go look on the media this afternoon to see what the news is saying about this remote trial proceeding. Don't go on to Courtroom View Network, CVN, to see if you can watch yourself on there or watch other jury panels. Please do not do that until you know for certain that you're not going to be serving in this case. Once you know that, then you can go do all the research and look at all the media coverage to your heart's content. Also, if you are selected to serve on this jury, you cannot speak to any of us. We can't speak to you. So if you see us over the weekend and for some reason we cross paths, when I say we, I mean myself, all the participants, all the court personnel, if we cross paths, either digitally, electronically, you see us somehow through social media, you see something that has us on there or some way to connect electronically, don't do it. And also if you see us in a store or at the beach or some social setting in a restaurant or whatever or grocery store, whatever the case may be, we can't talk to you. So if we see you and you see us and you want to get our attention, my practice is I look the other way, because I can't have any contact with you or any communication with you unless it's here in this courtroom in the presence of the court reporter. So Mr. Kaczurgas, he's under the same order. He can't talk to you either. Even if you already knew him, he can't talk to you unless you know for sure, and he knows for sure, that you were not selected as a juror in this case. Do not discuss this case with anyone. That includes family, friends, coworkers, neighbors, acquaintances. They may know that you're here for remote jury duty. That's perfectly acceptable. Tell them where you're at this afternoon. But they may come to you immediately when you're done and say, tell me all about, what was it like? What's it about? What's the case about? How are they doing it? And please, please do not talk to them about your experience or about this case until after you found out one way or the other whether you're serving. If you get a letter or an email saying you're not going to be serving, that you were not selected, you can talk all you want. If you get one that says that you are serving, you absolutely cannot talk until your service is completed and you're discharged. If for some reason this afternoon you're asked about your schedule and about what's going to happen, if it's an employer, family member, coworker, what have you, it's okay between now and whenever you find out whether you're serving to let them know about the schedule, about how If you're selected, you'll be serving for the entire day on Monday and possibly going over into Tuesday, just so they know how to plan for next week. And so that's perfectly acceptable, but don't go beyond that to talk about anything further. With that being said, I'll call upon our special magistrate, Ms. Hodak, to see if there's anything I've left off in my concluding instructions before I send these jurors on their recess. Ms. Hodak?
No, sir. Thank you.
All right, and then I'll also ask our remote bailiffs, Mr. Smith, Mr. Muse, and Mr. Estelila, is there anything I've left off in my recess instructions to these jurors?
No, sir.
Not from us, Your Honor. We will get the emails out as soon as we know, where we're sending them. And I would like to say one thing, that I agree with you, that having these jurors participate was a pleasure and a lot easier on us than we thought it was going to be. So thank you all for participating. We really appreciate it.
And when he says it was a lot easier than we thought it would be, he was talking about me, not you. You all are wonderful. I'm the one they have to worry about with the equipment. You guys were wonderful. Even Mr. Pearson was amazing. I've never seen anyone more graceful with an iPhone 6 than Mr. Pearson, moving about his house and reclining and standing up. So you did an excellent job, Mr. Pearson. So great work. And so what we're going to do now for the record is I'm about to excuse these jurors. So I'm going to tell our bailiff right now, you can go ahead and prepare a screen with the short recess, the short recess slide. Once I excuse these jurors, we're going to take a recess for 10 minutes for a comfort break for the court personnel and for Mr. Kaczurgas to talk to his client about all the jury panels before we come back together to pick the final 8 jurors. So with that being said, ladies and gentlemen, our fourth and final jury panel today, thank you so much for your service. Because of what you've done today, the sound of freedom has returned to the Duval County Courthouse in a remote way. And for that, I will always be grateful, and so will all the participants. Thank you so much. Have a good day. If I don't see you again, have a good day and have a great weekend. Stay well and stay healthy. Thank you. You may now leave the remote courtroom. Okay, we will now be in a short recess for 10 minutes so we can take a comfort break. Mr. Kaczurgas can talk to his client about the jurors. All right, we're in recess for 10 minutes. All right, is everyone ready to go back on the record? Is our production team with CVN, are they also ready? Mr. Smith, are the production team for CVN, are they also ready?
Your Honor, give me 1 second to check.
They're still in recording, Your Honor, based
Okay,
off.
that's all I need to know. Right, so I guess let's go ahead and go back on the record then. We're back on the record in the case of Cayla Griffin versus Albanese Enterprise, Inc., 2019 CA 1555. Mr. Muse, can you confirm for the record that all of our prospective jury panels in the fourth and final group have gone into recess for the day? They're no longer here in the courtroom.
Yes, Your Honor. All jurors have left the remote courtroom.
And have you confirmed that everyone that would like to be present and spectating here today, other than the CVN audience and the courtroom personnel, are present, including the media? Everyone signed in that is entitled to be signed in. There's no one in the waiting room?
No, Your Honor. No one in the waiting room. Everybody is in the remote courtroom.
Okay, very good then. We're back on the record now. We took a brief recess after the conclusion of the jury selection process with the fourth and final panel for everyone to have a comfort break, but also for Mr. Kaczurgas to talk to his client about the jurors and before we get to the point of picking the final 8 jurors. So Mr. Kaczurgas, you're here with your client, and our court reporter is also present. Have you had an opportunity to talk to your client? Do you need more time to discuss the jurors?
No, Your Honor, we're ready to proceed.
Okay, so by my notes, we excused it, and I'm starting with the first day yesterday. We had 2 panels yesterday, the early morning panel and the what ended up being the midday panel as opposed to the other morning panel. So the first panel, which was juror numbers 1 through 15, we excused several jurors. We excused juror number 3, Miss Hedgeduck, for hardship by my notes. We also excused Mr. Booth, juror number 10, for hardship. And so our first 6 jurors would be juror number 1, Miss Bean, juror number 2, Miss Burns, juror number 4, Miss Roberts, juror number 5, Mr. Vega, juror number 7, Mr. Kindler, and juror number 8, Mr. Wells. No. 1, 2, 3, 4. That's right. That's our first 6 jurors. We didn't have a response from what would have been juror number 6, so that's why we're at juror numbers 1, 2, 4, 5, 7, and 8. So out of those first 6 jurors, Mr. Kaczurgas, you have 3 peremptory strikes, and obviously, are there any cause challenges you'd like to exercise on those first 6?
No, Your Honor.
Okay, are there any peremptories you'd like to exercise?
Yes.
Okay.
The first peremptory that the plaintiff would exercise is on juror number 1, LaTanya Bean.
Okay. All right. And that would bring into our jury juror number 11, Franny Lasher. So those are now our 6 jurors. Do you accept those 6 jurors, or would you like to exercise any further peremptories?
I have some more peremptories I'd like to exercise.
All right, go ahead.
Okay. The next peremptory that we would exercise, Your Honor, would be juror number 4, Deborah Roberts.
Okay. All right, then so far we've had Miss Bean excused with a peremptory, and Miss Roberts a peremptory as well. That brings into our jury juror number 12, Thelma Smith. You have, by my count, you have 1 peremptory strike left, Mr. Kaczurgas.
And Your Honor, I don't know if you can hear me, but
You're frozen on the screen, but I could hear what you were saying, but you're frozen on the screen.
It may be due to this weather rolling in.
I know we've got rain and I can hear thunder. It's kind of hitting the window here in the physical courtroom 601.
He's back. Can you hear us now, Mr. Kuchergis?
I can.
And we lost you again. I'm wondering.
You're frozen again. Let me see if I can
Mike, you're muted.
get on to
Okay.
my file.
Okay.
Mr. Kuchergis, are you the iPhone? We have an iPhone in the waiting room.
I have an iPhone somewhere, but
That's okay. If you're not trying to join in using your iPhone, that's probably.
no, I'm on a laptop through a port. It appears the issue is resolved. Everybody appears to be moving on my end. Can you hear me?
Yes.
So Mr. Estelila, is there someone on an iPhone that you need to check on to see who they are and all of that? I don't know who they are.
I'm checking now, Your Honor.
Okay. All right, well, let's continue on. Mr. Kuchergis, by my count, you've exercised 2 of your 3 peremptory strikes. So we've got, right now, I believe that brings into our jury, that brings in Ms. Smith, juror number 12. We got jurors 2, 5, 7, 8, 11, and 12.
Yes, sir.
Okay. Are you satisfied? Do you accept those 6 jurors, or would you like to exercise another peremptory?
We would like to exercise one more peremptory.
All right. Who would you like to exercise it on?
Juror number 7, Ross Kindler.
All right. I believe that's all 3 of your peremptories. That brings in juror number 13, Ms. Khan. We now have 6 jurors. Do you accept those 6 jurors, or do you feel like you have any cause challenges?
No, Your Honor, we'll accept those 6.
All right, then that are 6 jurors. For the record, our 6 jurors will be juror number 2, Ms. Burns. She'll be juror number 1 in the, I'm going to call it the jury box. I know we don't have a remote jury box. We have, theoretically we do. They're going to be on the screen, but it's important for us to have these juror numbers assigned to them the whole trial. So juror number 1 will be Ms. Burns. Juror number 2 will be what was previously numbered as juror number 5, Mr. Vega. Juror number 3 will be what was previously numbered as juror number 8, Mr. Wells. Juror number 4 will be who was previously numbered as juror number 11, Ms. Lasher. Juror number 5 will be what was previously numbered juror number 12, Ms. Smith. And juror number 6 will be what was previously numbered juror number 13, Ms. Khan. Those are our 6 jurors. And so then that brings into play, and before we go any further, one final time, Mr. Kuchergis, do you accept those 6 jurors?
Yes, sir.
All right.
Plaintiff accepts those 6.
All right, very good then. And that brings in alternate jurors. So we're going to have 2 alternate jurors. So that would bring in the last juror, Mr. James, and then the first juror in the afternoon session, who is Miss Joyner Rogers. So you have one peremptory challenge on the alternates. Mr. Kaczurgis, do you accept what was presently numbered jurors 15 and 16 as the two alternate jurors, or do you wish to exercise your alternate peremptory strike?
We'll accept those two, Your Honor.
Okay, so our alternates, this is very important, Mr. Smith. The jurors aren't going to know who the alternates are. So, but from our numbering system, I will know who they are because juror number 7 will be the first alternate. And this is not, you don't tell them they're an alternate. You don't even mention the word alternate, but juror number 7 will be what was presently numbered juror number 15, Mr. James. And juror number 8 will be the second alternate.
So, Your Honor, they get the same email as 1 through 6?
Yeah, they're all getting the same email that they've been chosen to serve as a juror in this case. There's not going to be any different email between our 6 jurors and our 2 alternates. So juror number 8 will be what's presently numbered juror number 16, Miss Joyner Rogers. And those are our 8 jurors. So Mr. Kaczurgis, do you accept those 2 alternate jurors, Mr. James and Miss Joyner Rogers?
Plaintiff does, Your Honor.
All right, very good then. All right, well, we have our 8 jurors. And so what's going to happen now, and here's what I need to ask you all as our remote bailiff. You all, I know you already have gone to great lengths with all the assistance of Miss Hodak and Mr. Pataka and Mr. Corrigan to put together a form email for our 2 different groups of jurors, those selected, those not selected. So as it concerns those that were selected, my question is, after seeing what we've seen so far this week, everything's gone as well as you could possibly hope. But my question is, it seems like that on average, between the 4 panels we had so far, it's about a 30-minute process at best to get them checked in, get their devices going, do the PowerPoint, and confirm their identification. So is it possible, and I don't want to upset the apple cart, I don't want to cause any angst. So is it possible for them to check in at 8:30 with the understanding the trial is still starting at 9 o'clock? Or do you just want to keep it as 9 o'clock and they'll show up at 9? That means we probably won't start the trial till 9:30.
You're muted, Mike.
You're muted, Mr. Smith.
I think bringing them in towards 8:30 would be great. One of the things, the only thing we're going to change on the email that we're sending out in a short amount of time to these 8 is that we're going to tell them that at any time, there's only 3 steps on this second email. It's not like the first one that had, I think, 8 steps or something. But this one does involve a background, another attachment, which we think may be a little more complicated for some people. And for some people, just so you all know, it may work, it may not, depending on what kind of device they have. But that being said, we're going to offer for them to contact us at any time between now and Monday, Mr. Muse and myself, to help them get acclimated with the login process. The other thing they're going to have to log into is Sophia, so that they can get to the witness question form, and then eventually, when we get to deliberation, those other 2 forms. So we want to make sure that they're comfortable with those type of things.
Okay. Right, so let's do that then. The email is going to tell them to report at 8:30 on Monday morning to whatever invitation that you're going to give them for trial. And Mr. Smith, for all the other participants here, you're going to be sending out an invite for the trial to make sure that they all can get in. And that includes I'm assuming we have media that besides CVN, we have other media that want to watch, with the understanding that they're not going to be recording or taking photographs of the jurors and that type. Same rules we've had here in jury selection. You have all that in place, ready to go?
Yes, sir.
Okay.
And Mike, can you hit send on that email that we were just talking about?
Yeah, I'm sorry. I had it up in case you wanted to.
And I'll start working on those.
And Mr. Smith, I know you're probably going to do this anyways, but I would note that juror 15 16 appeared for jury selection by phone, so they might want to be offered the library.
That's a great point, Ms. Hodak. I had that note on my list too, but I didn't bring it up. So that's a great point. The phone, as we can all tell, the difference between phones and laptops, we've seen all kinds of things, all kinds of things with phones where people are trying to hold them for an hour or two or whatever, and it's very difficult. And then you have other people that they lose their battery charge, they're moving from room to room. And then we had the one juror this afternoon who was having to lay down with the phone. And so I just think if there's any way, obviously if they're not able to or not willing because of COVID, like Mr. Pearson this afternoon, I'm not going to force anyone to go to the library if they don't want to. So it's going to be an option if they like to exercise it to get a better view and a better screen and all of that. But I'm not going to force anyone to go.
All right, I think what we should do is offer, that option when we send this email to them today.
Okay.
Let them know to contact me so that I can contact the library so they can have, if somebody did choose it, they said they needed a little bit of advance notice.
Right.
So, James, before we send those emails, let's craft up that one sentence and just let them know that that's an option.
Okay.
Good idea.
All right.
Your Honor, I had a point about your instructions to the media about recording. Do you want to talk about it now, or do you want to? I knew we were going to have a housekeeping session later. Would you prefer to talk about it then?
Okay, we'll talk about in the housekeeping session. That'll
Yes,
be
sir.
after we're done on the record. So all those loose ends as far as logistics and equipment and technology, that doesn't need to be on the record for this trial, but for the trial record itself, that's a different matter. It's more project oriented, but we'll focus on really the housekeeping matters to wrap everything up on the record here today before we go into recess before Monday morning. So let's go ahead and try to deal with those issues, those items before we go in recess and have our separate meeting about logistics and technology. So, the things I wanted to address as it concerns Monday that I think need to be on the record is I'm going to kind of consider this to be a charge conference, so to speak, because I don't normally do it this way, but sometimes in trials I have multiple charge conferences. Mr. Rogerson's seen me do that before, or I'll do more than one. But in this case, I feel like we need to have it final. And the reason I say we need to have it final is because the verdict form, Mr. Smith has to have it loaded up in the software so the jurors can do things to it electronically to fill it out. Then also you may recall that my preference is that when I read the final instructions, not the opening instructions before opening statements, but the final instructions before and after the closing arguments, I like to have those scrolling on the screen. One of our mock trials, Mr. Smith had our mock trial materials instructions on the screen. And when I was in felony division, I had a practice of having those instructions on the screen as I read them so the jurors are hearing it and reading it at the same time. And so Mr. Smith did that through the share screen. And then obviously the instructions go back into the jury room with the jurors. They'll have their own copy in the whatever we're using, Dropbox, to get everything in there. So I want to get those to a final point today so we can get those to Mr. Smith and he can have them ready to scroll, or whoever's going to be doing it as I read them on Monday afternoon. And so I have a set of jury instructions with me. And so the question I have, Mr. Kaczurgas, is for the jury instructions. You have at the beginning of the day, you have all the traditional ones, 202.1, 202.2, and so forth, all of the usual ones that we give before the opening of a trial. And after 202.1, you can insert any instructions on the law that you want to have given. And I didn't have any guidance, I didn't have any instructions from you as to what you wanted me to put into the instructions before opening statement on the law. And Mr. Smith, you won't have to worry about these as far, they're not going to be scrolled on the screen. They're not going to be shared on the screen. This is what I'm going to be reading to them before opening statements. So this is not something you have to worry about for visuals. So what my question is, what should I insert between 202.1 and 202.2? I've seen lawyers do it different ways. Some want law instructions, some only want a few, some want none. I've done it both ways. I'm not wed to one way or the other.
You're muted, Matt.
Happens to the best of us.
That's okay.
Your Honor, I do think I want a brief instruction there, and if we could read 501.1. 501
This is the order you want me to read them in?
in the introductory instructions?
Yes, in the introductory instructions. 501.1, then what else?
501.2.
Okay. Anything else you want me to give in the introductory instructions?
Yeah, I think those are the only two that I'd like at that portion.
Okay, well then that's what I'll do in the opening instructions. And then, so what that leaves is at the end of the trial, your closing arguments are going to be sandwiched between my initial instructions, final instructions, and then the final instructions, for lack of a better term. And so those are the ones I'm going to have in written form that I've got the signature page for here that you made up for me the way I like it. And so I'll read these final instructions to the jurors. I'll sign the cover page, and then these will get e-filed or tendered to somehow they'll get into the court file after the trial is concluded. And so those I have in front of me. So I have 501.1, 501.2, 401.3, 501.8, 601.1, 601.2, 601.5, and then that kind of ends the first part of the final instructions. Then you're going to make your argument, and then when you're done with your argument, then I go to section 700, which is the closing instructions. And then when I get to there on the second page of the closing instructions, at section 700, there's a place for me to read the form of the verdict. And so the verdict form is what you provided earlier. I think it was either earlier this week or end of last week, where you says, "We, the jury, return the following verdict." And then it just has Miss Griffin's medical damages, including all medical bills sustained by the plaintiff caused by the incident in question, past and future. And then the second question is, what is the total amount of the damages suffered by plaintiff Cayla Griffin for pain, suffering, physical injuries, mental anguish, and emotional distress caused by the incident in question in the past and the future? Is that the same verdict form that you sent over to Mr. Smith, Mr. Kaczurgas?
It is, Your Honor.
Okay, so I think we're all on the same page with that. So Mr. Smith, from my perspective, this is, and then we have 801.4, which is instruction upon discharge of the jury. I'm not really worried about that one. That's the one, I mean, that's the one I'll give after the trial is over. And that's an easy, and I'll probably add some language in there about the survey, because we need to have, I need to make sure and remind them that they'll have a survey and the follow-up email to fill out. So I'll take care of that. But my big concern was to get through the substantive instructions and the verdict form. So Mr. Smith, Now that we've confirmed that, Mr. Kaczurgis, are we on the same page? You and I are on the same page?
I believe so. However, I do feel compelled to raise, Your Honor, in looking this over, the statement of the case that I furnished to the court unfortunately has an error about the date. And so if we could maybe fix that before Monday in terms of correcting the actual date instead of
Yeah,
February 20.
That's in the opening instructions, right?
Yes, sir.
Yeah, that one, okay, let me make that note, because I'm not going to be following the opening instructions for the clerk, just the final ones. Okay, so the opening instructions, let's see, it's in the introduction, let's see. Where's it at, Mr. Kaczurgis? Is it? .1 has, it just says that Albanese has been determined to
Held
be.
liable. Yeah, I don't know that maybe we
I don't see it. I don't see a date in there. I gave a date during all the jury panels, a date and specific description. Where in the jury instructions, either the opening ones before opening statement or the final ones, is there a description of the case?
I don't think it is in there. It's my bad, Your Honor. I don't think we need to address it.
Okay. All right. I think we're on the same page then. So, Mr. Smith, here's what I'm going to do.
Excuse me.
Go ahead, Ms. Hodat.
I apologize. There is a date on page 4, description of the case, 201.1, and the date is February 26, 2018. Is that what you were referring to?
Well, those are the instructions before jury selection.
Yeah, we've already been through
I've
that.
already covered all that.
Hmm.
Yeah, that was my introduction, so to speak, is a blend of the standard instructions and my own comments. We're allowed as judges to kind of blend all those together. And so that's why they're longer maybe than what's in the, I know they're definitely longer than the standards, but I'm covering not only the remote stuff, but extra stuff that I think is important for the jury. And especially since we're not doing a traditional jury qualification where we wave the flag and do all those inspirational things. So I'm having to blend a lot of stuff together. So yeah, so when I talk about jury,
I just wanted to make sure.
no, that's a good point. So my jury instructions are actually, what I'll probably do to save time is, so Mr. Kaczurgis, I know you probably got a lot to do this weekend, but what I'll probably do, unless you have an objection to, is I'll just, on the final instructions, I'll just mark through your page numbers and put, just put the correct page numbers on there with my initials next to it, unless you have time and want to, do the editing. But I think I'll do it this way, unless Ms. Fields, I may see if Ms. Fields can do it for me, so I may get that done over the weekends. Sometimes she can chime in and do it, or we'll get it figured out one way or the other. So the jury instruction cover page, I'll somehow get rid of the page 3, then where it says 501.1, that would be page 1. That was what was page 20 through 28 will be renumbered as pages 2 and so forth chronologically. So we'll have to fix the page numbers either by writing or by get the Word version and correct it. And then
you're going to have 20 through 28 appear where, Your Honor?
So my final instructions to the jury will be, when I say final, I'm not talking about the opening. I'm talking about the instructions I'm giving them before and after your closing argument. You have your cover sheet, which you have numbered as page 3. So that's going to be your cover page. And then what is presently what you've got page number is 20 through 28 will be renumbered sequentially from there.
Okay.
So those are going to be I'm calling them the final instructions, the closing instructions. They're the ones you're going to be given that it's going to sandwich your closing argument. Then the verdict form is right behind that at the very end. And so, Mr. Smith, in scrolling these, I'll try to get, I guess what I'll try to do is get this corrected and then send it over to you. get the page numbers off and get it sent over to you. And then what we'll do is you'll put it on the screen and scroll it as I read it. And so when you get to the very last page, you'll have the verdict form, and that'll be on the screen as the very last page, and I'll review that verdict form with them. And but it'll be on the screen. So all this stuff that I've got in my hand here will be on this share screen as I read the instructions to the jury. So as I read a page and finish it, you go to the next page. And so just like we did in the mock trial.
All right, and then because the verdict form is in Sophia, they'll see what it looks like.
You're going to see it in my hand, but y'all, Ms. Hodak and Mr. Kachergis were kind enough to kind of change the language and the instructions to cover the fact that they're going to be doing it in the computer program.
Okay, I hadn't seen that, but that's perfect.
Yeah, they did a great job. They modified it to refer to the court technology system. So I think that'll, I'll kind of give a brief. I'll try to ad lib a little bit, but not too much. I don't want to confuse them because you all are going to give them a PowerPoint presentation on how to do all this stuff when they're deliberating. So the part three PowerPoint presentation for Zoom skills would be on skills they need for deliberation.
Yes. And the verdict form didn't change though, correct?
No, it didn't change.
Okay.
It's the one that was sent to you. I think it may have been Friday last week, or either Friday or Monday, one of the two. It's been about a week.
Your Honor, can I make a request of when the finals get sent to Mr. Smith? Can I get a copy of those as well?
Yeah, so I'll try to get that done. I think you sent it to us in Word, I think. So I think it's just a matter of fixing the page numbers.
Okay.
Okay.
Your Honor, if we can, while we're all together, I would still like yourself, Ms. Hodak, and Mr. Kachergis and Ms. Griffin to see what we're providing in that final product of the verdict form to make sure,
No, that's fine. I was on my list of things to do.
Okay.
Was to cover that, to make sure he's satisfied while we're on the record that he's satisfied with the way that's being done on Sophia. So that was one of my punch list items to do while we're on the record. So this is probably an appropriate time for you to go ahead and do the share screen. So for the record, our court technology officers are going to put on the share screen the way that this verdict form is going to look when the jurors see it in the jury room, to make sure that it's consistent with the way that Mr. Kachergis would like to have it, and it's consistent with the way the verdict form, the physical verdict form looks.
All right, Patrick, will you run that and share your screen? You mind? Thank you. So, Your Honor, I'll kind of talk as Patrick's driving so that we can get through this a little easier.
Okay.
When they log in, when they being any juror logs in, they only see this one department now. We've removed everything else for the sake of clutter and for the sake of simplicity. So when they click on this, they'll see these three, but they won't see the jury inquiry form or the verdict form until they're in deliberation. So the only thing they will see when they first come in Monday is that bottom one. And that's the one that walks them through that question form for the witness that we created. Do you want to see what that looks like, or?
Yes, I think that
Okay.
Mr.
Let's start with that one, Patrick.
Okay.
So just so you know, we can hide any of these at any time. We just go in and click a button and they either see them or they don't. So we'll hide the other two until deliberation. So this is the first screen, and these look just like, kind of like the ones for the questionnaire. We do everything as consistent as we can. And so they'll come into this. And then the next one is, what's the question? And I
These are
believe,
for questions for the jury to ask a witness through the court.
yes, sir.
Okay.
Correct.
And we'll be monitoring this. So we'll see when one pops up. If they do one, they don't even have to tell us. We'll just see it, and then we can get notification to the court that there is a question from, after the witness is done. We'll be, I think, Your Honor said he would cue us. And we would say, yes, Your Honor, there's 3 questions.
The cue will be at when we don't have an opposing attorney, so it's really only going to be one set a Mr. Kachurgis will finish his questions. There's not going to be any cross or redirect because there's no other attorney. So at the conclusion of his questions, when he'll either signal by saying that's all the questions I have or whatever he's going to use, I will then turn to the jurors and ask if any of them have any questions of the witness. If so, please raise your hand. And then with that, I'll try to keep an eye out on the jurors on the screen. We'll have less of them on there to keep track of. I'll try to keep my eye on the screen, but also the bailiffs can as well in case I miss someone. And then I'll give them a moment or some time to type out their questions with the form that you're using.
Very good, Your Honor. So once they type in this question, if they're done, they can hit save and exit. If they have another, there's a question, yes or no, that gives them that path, which path they're going to go. If they hit yes, then it just keeps putting those questions on that same sheet of paper, just like you showed us to put in there. So that worked great. And that's it. That's pretty simple. And then we're going to show you real quick what that one looked like. We'll just have to change our login. They don't see the document. They don't need to. We just forward it to Your Honor.
Okay.
And so here's what we would be forwarding you.
Bottom left, Pat.
I have to switch my sharing screen real quick. All right, can anybody see this?
So that's where it's got the case number, it's got the witness, and the style, Griffin versus Paradise. And this is a question field. That's what he typed. So
So it just keeps building of how many questions they have. They have all the way up to item number 18. They want to keep going, asking.
I've never had a juror ask more than, I think the most I've seen is 4 questions, 5 questions.
Yes,
Your
sir.
Honor's probably glad he's never had me as a juror.
And Your Honor, you can print that afterwards and you can use those fields to the left to handle
Or your records, and that's set up the way that you gave it to us.
Yeah, that's the same way I do it in a physical question form. Mr. Rogerson's seen that before in trials.
Are we okay with this one? We'll move to the next.
I'm fine with it. Mr. Kachurgis, are you okay with it?
No objection.
Okay. All right. So that's the form we'll use. And the way I'm going to do this is when it gets sent to me, I'm going to save it to my desktop here on the screen to my left. And then I'll print it so we have something I can mark as a court exhibit. And then Mr. Kachurgis, I'll have you come to sidebar at the court reporter, and then I'll share screen on that question. I'm not going to try to send it to you. I'm just going to share it on the screen with you. And then I'll hear from you as to whether you have an objection or not.
Very good.
All right, Your Honor. And then the next one would be where they would see once they're in deliberation.
Okay.
Let's say they had a question. They would click on the jury inquiry form.
Okay.
It looks the same as the other, just a little bit different question.
And by the way, let me interject real quick. Your Honor, any of the text description, anything like that doesn't suit anyone, we can change the verbiage on it on the fly, so that's not a big issue.
Very easy for us to manipulate this.
I have a question.
Yes, sir.
Does each juror have access to this, or is this, once they are in deliberations, does this all go through the foreperson?
How do you want it? How do you want it? We could.
Well, the
I'm just thinking
foreperson has to be one to sign the question. So whether it's a verdict or the question, the foreperson signs it. However, that doesn't mean the foreperson's in control of whether a question's asked or not. It's really just a formality that the foreperson signs the question or the request. But it's something that another member of the jury may say, I really need to see this, or I really need to do that.
And they'll all need it for the inquiry form.
So
Okay.
I guess my question would be, and I think Your Honor and I talked about this. Let's just say Patrick, James, and I were 3 of the jurors, and James is the foreperson. if I had a question, do I ask him, say, hey, I have a question, I need to see something? Or do I just submit it myself? I thought I had to go through him anyway.
The foreperson is not there to say that I approve of your question or I disapprove of the question. The foreperson is a facilitator. He's a moderator. He or she is someone who's going to be, I guess, promoting and encouraging discussion, making sure everyone's heard. I'm being very summary on, but that's what their job is. So they're not there to filter the questions. They're there to be kind of the one to keep things on track. So if someone has a question or request, the foreperson would fill out the form and then sign it, regardless of whose question or request it is, and then get our attention, have it heard by us. We don't care which juror had the request. It's just that they as a group someone has a request, or they all do. But we want to, that's got to be signed by the foreperson.
Very good.
I understand that, Your Honor, but I guess I'm asking is, does a request of a non-foreperson juror have to get submitted through the foreperson, or can they all do it individually?
It's I think that the way we could do this is the juror could type out the form if there's a way to share it with their fellow juror to be signed, because the foreperson has to sign it
Before it's submitted.
right before, just like in a regular proceeding. Forepersons, if you read the standard jury instructions, the foreperson signs it and it gets delivered to the bailiff, who then brings it to me. That's in an in-person courtroom. So we're trying to mimic that here. So there's one of two ways to do it. The form can be shared. If it's something that a juror could fill out, then send it to the fellow juror the foreperson, who could then sign it electronically, then get it to the bailiff, then I think we've accomplished the same thing. Or if that can't be done, then what would happen is the juror would tell the foreperson, I really have a question that needs to be or a request I need to have handled, and then the foreperson would have to type it up and send it to the bailiff. Either way.
I think you've answered my question, that it comes through the foreperson.
It's got to funnel through. It's got to come through, not to approve the question or request, but just to
submit
to sign off on.
Then, Your Honor, the only way we can do that, because this wasn't designed to pass, from one juror login to another juror login, they would not finish. If I was juror number one and I had a question, I would fill it out, and then I would say, foreperson James, my question's up there. Can you please sign it?
Right. That's the way that'd be fine. I think that's perfectly acceptable. I don't think there's anything wrong with that, because we still are getting a formal signed question, regardless of who typed it. As long as it's signed by the foreperson, I think we're good to go.
Okay, well, that would be the only way we can make the current setup that we have work, is that if it was juror number one with the question, the foreperson, say they were juror number 6, would have to log in as juror number 1 and type the name to sign it.
Well, as long as there's a way to get the foreperson to sign it, that's
Okay.
acceptable. But we just have to get something tangible from them.
Okay.
Or in the alternative, the foreperson could retype it in
Right.
his
That's what
login and sign it.
I think probably the easier thing would be, maybe if the juror that has a question can they share screens between each other?
Of course.
Yeah, so they could share a screen with their question. The foreperson could just type it out and copy it verbatim, read it off to the other juror and say, is this what you're asking for? Yes. And then foreperson can sign it and electronically sign it and get it to the bailiff, and away we go.
I like that. I like that idea better. I don't know about.
I'd rather do it that way than have jurors log in as each other. I think that's going to get confusing. So in your Zoom tutorial part 3 for skills needed for deliberation, how are you handling that explanation for them?
Well, we're working it out right now, so we're just gonna do it like Your Honor just said, unless there's an objection.
No, Mr. Kaczurgas, are you okay with the juror sharing screen and the foreperson just type out exactly what the other juror had in their written request?
I'm fine with that, Your Honor.
Okay, let's do it that way then.
And Your Honor, and Mike, you might already be there, but if that's the case, if it's possible, you'd only give that option to the foreman then.
Right, the foreperson could be the only one to be able to sign off on requests.
I'm saying that the other jurors shouldn't even have it on their screen so that they don't accidentally submit it themselves and then cause
Right.
issues.
It's not like that. It doesn't work like that.
Okay.
They'd have to log in and pull the unsigned one up. So-
Because what's going to happen is we're not even going to know who the foreperson is until after all the closing arguments. The way I do things is, and we've done this in the mock trials already, so some of you may remember this. The jurors go back to the jury room, and they're gonna select a foreperson. That's all going to be going on while you all confirm that the exhibits are going back into the jury room. Are we using Dropbox, or what are we going to use to get the exhibits back there?
Yes, sir. That's the only solution that the court had. I didn't know, but after talking to Mr. Cates, he preferred me to use our Dropbox, so that's what we're using.
Right, so the exhibits, before those get Dropbox, Mr. Kaczurgis is going to need to review them along with the clerk to make sure Mr. Rogerson and Ms. Irizarry are going to have to be all together here while the jurors are picking their foreperson to confirm that what's going back there is what should go back there. So their Dropbox is going to be the exhibits in electronic format, the set of jury instructions, and then the verdict form. And the verdict form is going to, the instructions are just ones they can read. There's nothing to fill out in the instructions, just something they can refer to and read if they want to refresh their memory as to what they were instructed on. But the verdict form is what's going to be in a fillable format. So in your PowerPoint part 3 with Zoom skills needed for deliberations, you're going to have to put together a very simple tutorial on, this is all stream of consciousness, so I'm inviting everyone to chime in if there's something I'm leaving out. They're going to need to have some basic skills on how to handle the question or the request of the court. So question or request is that form that you already have, but how to fill that out. We talked about that they're all going to have access to the form, but it has to be signed by the foreperson electronically. So that goes back to the option of sharing the screen, that if a juror has a request or a question, they can either verbally tell the foreperson what they want, the foreperson can type it out and share their screen to confirm that it's accurate, or the juror can type their own question on the form and share the screen with the foreperson so they can copy it and get it exactly before they sign it and bring it and send it to the bailiff. That's number one. Number 2 is how to fill out, or how the process, the mechanics of filling out the verdict form. You got to have that covered. And then the other thing I think that has to be handled is, how are they going to get our attention when they have a request or a question or have a verdict or just anything at all that they need to bring to our attention? In ordinary in-person trial, they might bring to our attention that they're hungry, that they need to do this or that, or
So, Your Honor, there's an option when the jurors are in the breakout room. They have an option at the bottom of their screen, and we tested this. There's an option that says ask for help. And when you click on that, it gives you the option to send the host a message stating that they need help. So we would instruct them when they have a deliberation or if they have a question to hit that ask for help option. Okay. That would then alert me, because I'm the host of the actual meeting. And then at that point, I'd know to go in or, let you know about completed deliberation.
That's, Mr. Kaczurgis, is that acceptable? Obviously, we don't have a button like in a physical courtroom to hit with a buzzer. We don't have anything to make an audible sound. That would probably be the only electronic option we have. Is that acceptable?
And I guess it would ping Mr. Muse.
Right. It would signal him that they have a question, they need help, something just like in a normal.
Similar to a trial with the bailiff going in and handling whatever it is.
By analogy, it's the same thing, except it's electronic. So here in a regular courtroom, I'm sure you've been here for trials and someone hits the buzzer and we don't know what it is. We don't know if they're hungry, if they have a question or they have a verdict, but the bailiff goes in and finds out and then brings us the message. So this is electronic. This is by Zoom. It's remote. So Mr. Muse would be, as our remote jury bailiff, would then answer that help button by going in and confirming and finding out if they have a request, a question, or a verdict, or something else.
Whatever the case may be. Yeah, I'm fine with that.
Okay, so but Mr. Muse, so that's the other thing you got to cover in your tutorial. Those three major areas. So then, so I guess the other thing is, Mr. Muse, I need to make sure it's clear with you and the other remote court personnel. I know that you've never worked as civilian bailiffs before. You all are court technology officers, but no one, absolutely no one can go in the jury room while they're deliberating unless the help button is pushed by the jurors and they need help. You can't monitor, you can't go in there and watch them deliberate. You can't observe them deliberating. You can't turn off the sound and just watch them visually deliberating. None of that. We can't record them. We got to treat this just the same way we would if we were an in-person trial. This is a real trial, so we don't watch jurors in a real courtroom deliberate. We don't have cameras in there to watch them deliberate, so we cannot, no matter how interesting it might be or no matter how much value we might have by recording their deliberations, we cannot do that whatsoever. No one can watch what they're doing. Is that understood?
Yes, sir.
I have a
I
question.
fully understand that.
I have a question. If they are in deliberation, or if they hit that ask for help option when they're either in deliberation or the remote jury assembly room, and I get that pop-up, do I need to inform you before I go in there? Do I come on screen and say, hey, I've got a request for help from one of the jurors? Or
I think that would be a good practice, because in an in-person courtroom, what happens is when that buzzer gets hit and something sounds, usually what happens if I'm not hanging out in the courtroom, I'm up in my office upstairs, the clerk knows to call me or text me and say, hey, there's something here, come on down, even before they know whether it's a question or a verdict or what have you. So
Okay,
yeah, get our attention, because we want everyone to be here, because it's going to take a little while to get everyone here. Mr. Kaczurgis may not be sitting in that seat the whole time. He may be dealing with something else. His client may be dealing with something else. Ms. Hodak may be dealing with something. We all may be doing other things. So by alerting us immediately when the help button gets pushed, that brings us back to our seats.
Okay, and I had one other question, and this is more for Mike and Patrick. When they do the question form, the inquiry form, and it has to be signed by the foreperson, how are they signing it? Are they going to electronically sign
Yeah,
it?
it's just a S.
We're doing
S /name.
Gotcha.
So when we say signature, it's the way we've been doing the questionnaires and everything else. It's the S/name.
Okay.
And then, so I think, so you all have to get that PowerPoint together.
We
So-
have the majority of
Need
it
to make a few
together.
tweaks to it.
We just have to add a couple points to it, Your Honor. We do have a selected, it's titled Selected Jury IT Instructions, but we just need to go in and edit it and add a few more points to it.
Okay.
And have you also included in that how to use the share screen and how to use the Dropbox?
I don't know if Dropbox is in there. We can certainly add that, but I know share screen is in there. So we'll need to add, obviously, share screen, Dropbox, or share screen if it's not in there, Dropbox, skills on how to handle the inquiry form, how to fill out the verdict form, and how to get the bailiff's attention if a juror needs help during deliberation.
Yeah, I think we should
the help was
probably
already
make
in there.
sure. I apologize, Mike, go ahead.
I think the help, the pushing the button for help was already in there. It was in one of them that I did.
I think pushing the button for help is acceptable. I don't think we need to be too detailed on that. It should be fairly straightforward.
Ms. Hodak, what were you gonna add?
I was just going to say, I think it would be a good idea for us to make sure before we leave the jury room, after they get the instructions and before they start deliberations, just to verify that they are each able to open up the Dropbox and view the exhibits.
I think that's a good idea. So I think that has to be a practice. So Mr. Muse, normally what happens is when in a physical in-person trial, when exhibits go back to the jury room, Sometimes there's electronic exhibits that require the use of a laptop, and the bailiff will, or the clerk will explain to the jury, why they have a laptop and how to get access to the exhibits, and that if they have a problem to let us know. And then usually they'll give them a password to get into the laptop, and the exhibits, they'll explain to them it's on a CD or it's on a drive or whatever. And so those things are explained to them in the jury room. So I don't think this is any different, because we're going to have exhibits. They're going to be going to them in Dropbox. They got to know how to access the exhibit. So there needs to be something in there about how to do it. But then I also think it's appropriate for you to make sure that they can open them before they deliberate. Make sure that they can get into it.
Sure. Yes, sir.
All right. So here's my thoughts on the PowerPoint, because this is a very important PowerPoint that they're going to need for deliberations. And we need to make sure that it's right. And I'm not saying this be negative towards this court technology officers, because I know y'all are doing a great job, but I'm thinking it might, if it's possible, it might be good for us to review it, to look at it before Monday. I don't know if that's possible or not. I don't know if that's something that can be Dropbox to us, the PowerPoint, and here's what the PowerPoint has on it, something that we can see it in advance.
I'm working on it now, and I'll certainly, if I don't complete it before the end of the day, I'll have it done before Monday, well before Monday. It'll be done tonight.
Well, what I was going to say is if you could Dropbox it to Mr. Kachurgis and Ms. Hodak and myself, and obviously the other CTOs to review beforehand, I think that would be helpful. Is what I hate to have happen is we get to Monday and then there's a delay because we're not sure, whether the PowerPoint's correct or something was left out or something needs to be more clear. I think with our collective thoughts here, we can make sure that the tutorial is as generic as possible. It gives them the skills without doing anything inappropriate that crosses over the line in terms of getting into their decision making. So
Okay, and this is a question more for Mike and Patrick. Right now, the PowerPoint that we have, the selected jury IT instructions, as you know, it closely resembles that of the one we sent out originally. It just includes how to set a virtual background. I'm thinking now, for sake of some simplicity, maybe we should take how to mute and unmute and all those really basic stuff out of this second one to make room to include
they know how to do that already. So
I mean, a lot of this they've pretty much mastered at this point, muting and unmuting. I don't know if that needs to be reiterated in the second outline.
joining the meeting and all that, right?
How to join the meeting. Now, joining the meeting for this one's going to be a little bit different, and I do think it warrants an extra slide, because for this particular, for the jury selection, all they did was go to zoom.us and select join a meeting and type in the meeting ID.
Right.
For this one, they're going to get an actual login. We've created Gmail accounts for them, so instead of going to join a meeting, they're going to have to go to sign in and use their credentials that we've given them in their email to sign in. So we may, at the very beginning of this thing, started out with how to log into your Zoom account as a selected juror.
I agree.
And then kind of start it from there and then roll forward and eliminate a lot of these slides about, joining the remote trial, video and audio settings, chatting in Zoom, pinning a speaker, gallery view. They know about all of that now.
Yeah, we'll clean it up. And maybe you can include my contact information there as well.
Now, we don't want them contacting you, Patrick.
okay, so I think we've covered a lot of ground so far, and what I want to do before we wrap up today is I want to go through kind of what Monday's going to look like, so that we're all on the same page and we're not going to be in confusion on Monday. I want everyone to be on the same page, so that I think when you have confusion, you end up with this feeling of anxiety and being in a hurry, and then that's when mistakes are made and people start feeling self-conscious and all of that. I don't want anyone to feel that way. I want everyone to know what's happening and what's coming. So on Monday morning, our plan is y'all are going to email the jurors to be here at 8, to be in the remote courtroom at 8:30, so they can be immediately sent over to the remote. Now we're sending them to the remote jury room, because now they're jurors. So they're going to the remote jury room. And when they're in there, that's going to take about 30 minutes, just based upon what our experience is so far. So when they go to that remote jury room, they're going to need to do a couple of things. The first one is Mr. Rogerson will now be the one to confirm their identification so that they can be sworn in when they come in. And then also, whoever's going to be handling the PowerPoint presentation, we're now going to be on PowerPoint, the PowerPoint presentation part 2, which is Zoom skills needed for the jury trial. So now we're going to need, those are things we already talked about. They got to know how to do the question, the juror question of the witnesses, whatever other skills they need to be able to do while they're in trial. That's what we're covering. You're going to cover those things during those 30 minutes or so they're in the jury room before we get started. And then while they're doing that, then Ms. Irizarry will probably be, Mr. Rogerson, Ms. Irizarry will be with us on Monday, right? You're muted, Mr. Rogerson.
Yes, Diana will be here Monday, so there'll be 2 of us.
So what's going to happen then is you'll be in there confirming IDs. Ms. Irizarry will be in the courtroom with us. And when I say us, I mean myself, the clerk, the court reporter, Mr. Kachurgis, and Ms. Griffin, the plaintiff. And at that time, we'll go ahead and pre-admit the exhibits like we talked about. Those will be pre-admitted. They've already been marked. They'll be admitted into evidence. And also, Mr. Kachurgis will make his motion for directed verdict. And we'll check all the tech stuff, make sure we're all square and on the same page with that. And hopefully, we'll kind of do that 3-minute rule again. I don't think, well, actually, I think let's use a 5-minute rule on Mondays. I don't think those things will take me more than 5 minutes to get through that with Mr. Kachurgis and Ms. Irizarry and the court reporter and his client. That won't take more than 5 minutes. So when we get to the 5-minute mark in what's going on in the remote jury room, give us a signal, the 5-minute mark, because that tells me to go on the record with everyone to do my preliminary things. And hopefully we end up coming out the same point where they're done, we're done. Mr. Muse comes out and tells us that they're done, and I do that inquiry I've been doing.
Okay.
And so what's going to happen is when you come out, I'll do the same questions before, confirming that their IDs have been checked and that they watched the PowerPoint presentation and that they're all present and accounted for. They're going to come in the courtroom. You're going to do the remote call to order again, just like before, except now you're going to add that phrase on the script, Mr. Muse.
I don't understand why you gotta.
Mr. Muse, you're going to do that phrase on the script at the end that in parentheses that is the in trial instruction. So you'll see in there at the end it says use when in trial. Yeah, so you'll see that at the end where I put in parentheses to use only when you're in trial.
Right.
You'll give that as part of your remote call to order as well.
Okay.
So then what we're going to do is everyone will get welcomed in, the jurors and so forth. I'll do my same thing I did before where I check to see if they can hear me and see me and what device they're on, confirm all that stuff just like I did during jury selection. And then I'll check my list, make sure all the jurors have the correct numbers. So those numbers I gave you today, 1 through 8, that's what I expect the jurors to have on Monday. Not different numbers. They have to be those same numbers, 1 through 8. And then I'll ask Mr. Kachurgis if he's ready to proceed, just like a regular in-person trial. He will be, and then I'll be invoking the rule of sequestration of witnesses, which we only have one, who is Mr. Griffin. Is that correct, Mr. Kachurgis?
It is, Your Honor.
Is he going to be here is he going to be in your office waiting from the beginning on Monday, or is he going to show up at some later time?
As I sit here today, I don't know. I'm meeting with him as well as Miss Griffin tomorrow morning. I gave him a heads up that he may not need to be here Monday and appear remotely. So if you'd like, I can email the court tomorrow to let you know.
Well, the reason I'm asking is because we had kind of created this, or at least we were thinking through this process, that if a party had witnesses, we could locate the witness into the remote attorney conference room. If that's logistically possible, that may be just me using a lot of Zoom terminology that's not really realistic in Zoom, and I'm not an IT professional, and I don't claim to be. And so that may not be realistic. Those were things that we were discussing during the various mock trials. So if we can create such a room, if it exists, a remote attorney conference room, then we could have Mr. Griffin in that room when trial starts. He's not watching the proceedings, he's in that room. I could bring him into the courtroom in order to give my sequestration instruction. Then he can go back into that attorney conference room only to come back out again when he's called as a witness. If he's available, I would love to go through that exercise, because it would demonstrate how you can use the Zoom technology to mimic what we do in a regular courtroom, which is the rule of sequestration, where the witness can't watch what's going on. So that's what I would love for him to be here, because I think that would be wonderful if we could put him in that remote attorney conference room.
To put a finer point on it, you would like him here at 9 to go through that instruction.
Right, if that's possible. I mean, if we could have,
we can arrange that.
and if we could create I'm not going to use the Zoom terminology. I'm going to use my courtroom terminology. You can equate it to Zoom. But if we could create that remote attorney conference room that would mimic what's in the in-person courthouse, where we have these conference rooms where witnesses and people can go to confer, let's create that for Mr. Griffin, so that I can go through that exercise and show how we can do the rule of sequestration with a witness.
If I can, Your Honor, from the IT team, if you can please get me the Zoom link for Mr. Griffin at some point this weekend, so that we're not scrambling Monday to make that happen.
That's a good point, Mr. Kaczurgis. You're thinking like an IT professional now. So I'm going to say that's a brilliant thought, because Mr. Muse or whoever's going to handle this from the CTO staff, let's have a Zoom invite to the attorney conference room, for, if that's possible, for Monday morning, so that only Mr. Griffin and Mr. Kaczurgis can go in there. No, none of us are going to be going in there. That's the attorney conference room.
Well, there can't be a separate invite. They're going to get the same invite, because in order to get into the meeting, they have to have the meeting ID. That's kind of what hosts the entire meeting. But
well, then that's even better, because that really mimics what we do in the courthouse, because witnesses show up here, they come into the courtroom, and then the lawyer knows to get them into the attorney conference room. So they're going to show up here, and then Mr. Kaczurgis will let you all know, or somehow we'll know. And in those preliminary things that aren't on the record, that aren't on camera, you're going to then, Mr. Muse or whoever's going to handle it's going to move Mr. Griffin into that, what I'm going to call the attorney conference room, which in Zoom vernacular would be a sidebar or chat room, or not sidebar, but a chat room or a breakout room. And then when I do my rule of sequestration, which will be right here at the beginning of the proceedings, we can bring Mr. Griffin in, he'll appear on the screen. I'll give him the instruction, and he goes back to that attorney conference room.
And just as a suggestion, we could probably have it to where when he joins the meeting, there's an option that says, "Don't initiate my video." So when he joins the meeting, his video won't be shown. Therefore, nobody in the meeting will see him. But
no, we want to see him. We want to see him, because he's coming into the courtroom. So think about the physical courtroom.
Right.
When I invoke the rule of sequestration, any witnesses waiting outside, I have them come into the courtroom. They stand in front of the clerk. I give that instruction. I think to me, symbolically, that's a very important moment, because the jurors are sitting over there in a physical courtroom, and they see me invoke the rule of sequestration. All those witnesses stand there acknowledging the instruction I've just given them. Then they turn around and leave the courtroom, only to be seen again only when they're called as a witness. So I think symbolically that we're trying as close as we can to mimic and copy what a real courtroom is. So I do want his image on the screen. I do want him to be able to verbally acknowledge that he understands my instruction. And
Okay.
Kaczurgis will also acknowledge the instruction.
And Your Honor, if I may, James, I would include the witness background when you send the link for if we can use it, Matt, if Mr. Griffin can put it on, that's fine. If he can't, that's fine, but we have one, so we'll
I
send
may
it.
recruit y'all's assistance if I needed to get it installed.
And Matt, about that, I know you had originally said when I was with you setting up the PC that it may be easiest for the witness just to show up on the device we set up for Ms. Griffin. But I was gonna add, and Mike, I meant to mention this to you, but on that table he has that all-in-one on. I think there's room for another one, and if possible, we could put another one there with a PreSonus and split the mic so they can both be in that room with two different devices so that he can use that background. Otherwise, he's going to be shown on screen and it's going to say plaintiff when he's really the witness. I was just throwing that idea out there.
Is he going to be in your office, Mr. Kaczurgis, or is he going to be somewhere remote?
I can tell you tomorrow morning.
Okay. Yeah, I don't know. James, that's a great idea. I don't know if I can get that done before he has to appear.
I talked to him briefly the other morning, and I suspect he's going to be on his own laptop, and we'll put the witness background, and we're going to go that route is my suspicion.
Okay.
That's fine.
All right, so here, to stay on task here, before I do the rule of sequestration of witnesses, we're going to swear in the jurors. So that'll be Mr. Rogerson's time. He'll be on the screen. Mr. Rogerson will be visible. I'll do the same inquiry of him I did with Mr. Corrigan these past 2 days, which is that he's confirmed the identification of the jurors, and then he'll swear them in, and then he'll disappear from the screen, and then we'll proceed from there. I'm not planning on doing lengthy Zoom instructions about how to use Zoom and about not having people on there and all that stuff. I just did them yesterday and today. I would hope that I know you all are going to do things with them. So unless you want me to reiterate the same things I've been doing the past 2 days with the 10 rules or whatever, I wasn't going to do that unless you all want me to do it. Do you want me to do it or not?
If maybe a reminder of those rules, but not reciting all 10.
All right, well then I'll tell them to remember that all the rules I gave them for the remote courtroom, the 10 rules I gave them during jury selection still apply during the trial. I'll just remind them of that.
And Your Honor,
You might want to do an abbreviated form of them, Your Honor, since this group was there, they were there Thursday, they'll have been gone Friday, Saturday, and Sunday, so it might be good to have an abbreviated instruction.
Okay, well that's what I'll make a note to myself to put that in there, to insert that in there.
And Your Honor, through this whole process, whenever Patrick or James or either one of us are in one of those jury rooms, we're reiterating those things of not using cell phones, turning on and off. We do that too because you asked us to. So
I know, and I think it's good. The more times they hear it, the better. And because like I warned them this morning or the past 2 days, you can get so comfortable with this that you're like, oh, let me, like one of the jurors, he stretches out and looks like he's about to go to sleep. I mean, you can get comfortable with being at home to the point where you want to pull out your device. Let's check how things are going on the internet, and let's check out my messages. I mean, there's all kinds of temptations when you're in your own home. So the more times they hear it from all of us, the better. So I'll do a condensed version of those 10 Zoom rules, so to speak, just to remind them. And then after the rule of sequestration has been given, after that instruction has been given, that'll take us into the into 202.1, and then we're now into those introductory instructions that we've already covered. So that would be my plan for Monday. So that, anyone have any questions? We're still on CVN. To my knowledge, we're still being recorded. I'm kind of considering this kind of a case management conference / charge conference. So it is on the record. The court reporter is still here. So are there anything related to those matters that we need to address? I don't want to get into the housekeeping and schedule and technology stuff that's not going to be on the record, but as to the legal things that we have to address for Monday, anything at all, any questions, any concerns?
Your Honor, I just have one point of clarification. Earlier you mentioned about the exhibits being in the Dropbox, and we've already got the Dropbox established. There's already things in there, but I just want to be clear that it's not the court's IT responsibility to check those exhibits. So
No, it's not your job to check it. It's Mr. Kaczurgis's job to make sure that those are the appropriate exhibits. That's part of his job in representing his client. If we had another attorney on the defense side, the two of them would meet and confer and review what's going in there, just like we did during our mock trials, where they confirm for the record that what's going into the jury room is what's supposed to go in there. That is never the job of the bailiff or the court technology officer. The clerk will also have a role to play in that to make sure that what's going back there is what was marked as plaintiff's exhibits 1 through whatever. That's Mr. Rogerson's done that before with me in an in-person trial. He knows what it looks like. So I'm mimicking that in a remote format. So really this is going to involve you're more involved with the mechanics of getting it in there, Mr. Smith, but Mr. Kaczurgis and Mr. Rogerson and Ms. Irizarry would be the ones making sure that what's going back there should be what's going back there, no other surplusage.
Yeah, so the only thing we'll be putting in there is the instructions.
You'll send the instructions in there. You'll send you'll make sure the verdict form's loaded. The mechanics of getting those exhibits in there, not confirming which ones go in there, but getting them in there, who's going to do that in terms of the Dropbox send?
It's already, I think they're already in there. We gave Mr. Kaczurgis access to it and the clerk so that they could do the numbering and whatever else they have to do.
Right, but what we can't have is I can't have the jurors having access to the exhibits in the jury room until they deliberate. Is that?
They're not available. We don't even have they don't know the link yet.
Okay, good. All right, so I think I get the picture now. They're in Dropbox, but until the jurors have a link to it, they can't open it.
Exactly.
Okay, just like when we Dropbox stuff to each other.
Yes, sir.
Okay.
They don't even know. They wouldn't even know where they were at.
All right, so any legal issues, either with instructions or with my procedures for Monday, anything at all that we need to bring up before we, as in this case, go into recess for the evening?
Nothing for plaintiff, Your Honor.
All right, then what we're going to do here is we're going to go into recess for the evening. So Mr. Ashley, go ahead and pull up the evening recess slide, and that would be the 9 a.m. slide. We will be in evening recess now in remote division CVE in Jacksonville, Duval County, Florida, until 9 a.m. on Monday morning. Everyone did a great job today. You all have done a great job the past 2 days. I want to thank everyone for their time and their attention, their diligence here. And you all have made this a great 2 days. I'm looking forward to Monday and getting through the trial. And we're going to keep getting better and better as we go through this. So thank you so much for all of your efforts. Everyone have a good weekend. And I look forward to seeing everyone on Monday morning. Mr. Corrigan, anything else?
Yes, Your Honor. It was the housekeeping. I thought we were going to have a separate
We
session.
are going to have a separate
Okay.
meeting, but there's got to be a separate invite going out for just housekeeping matters. So Mr. Smith, you're going to do an invite for a separate meeting that's off the record that doesn't involve any legal issues. It really is just technology stuff.
I've got it, Mike.
All right, very good then. We are in recess then for this division as far as the case of Griffin versus Albanese until 9 a.m. on Monday morning. Thank you.